First topic of discussion is prison. Prison. Now, prison holds individual accountable for their actions, and it brings efficacy of criminal justice system. So, the efficiency of the CGS is dependent on the functioning of the prisons. Now, what are the issues related to prison? So, first issue is overcrowding. So, as per NCRB data, there is 130% occupancy rate in the prison. So, suppose the accommodation facilities are of just 100 prisoners, but there are 130 prisoners there. And recently, the NCRB report has also revealed that our population in the prison is about to hit 6.8 lakh. So, that is a very huge number. Then second issue is there is understaffing of prison and vacancies. So as per a NCRB report again, there is 28%. There are 28% posts which are vacant in the prison. Then third issue with the prison is the under trials to criminal. So there are 70%. The ratio of under trials to criminal is very inadequate. The 77% of prisoners are under trials. So out of the total people in the prison, only 33% of them are convicted. The rest are under trials. Then if you see, if another issue, there is a case study of Andhra Pradesh. So there is a caste and religion based discrimination also going on in the prison. So basically, they are segregating the prisoners on the basis of their caste. And another issue with respect to prison is that there was a neglect of women prisoners, and there is a lot of discrimination. So in the women cell, there is a lot of neglect of the basic facilities of the women, and there are various other issues which were suggested by the PS committee. Then the prison budget has been stagnant, so there is financial issue also. The budget is stagnant. Another issue is that death by number of suicide is 2x more than the average. So it is more than the global average and around twice of the global average. Then there is very inhumane behavior with the prisoners. Then the hygiene condition. This is also one of the major issue with respect to women cells. The hygiene condition is very poor. There is in the prisons there is high level of corruption. Then there is less focus on rehabilitation. This is also one of the behavioral issue. Less focus on rehabilitation. So these are some of the issues with respect to prison. Now, what can be the measures to rectify these things? What can be the measures? So measures is, first we have the government. The central government has bought the Model Prison Act. As you know that the prison is a state subject, so the union government has passed a model act, and now it's upon to the states to implement it in their states with or without amendments. So this model prison acts basically focus on reformation rather than retribution. Then it also focuses on giving legal assistance in line with our DPSP. Then it also has provisions with respect to digital prison management. So use of camera, use of AI based technologies in managing the prison. And then this act also has provision for open jails. Now open jails for prisoner, those who are behaving very good. So any prisoner which is having a very good behavior will be transferred to this open jail. Then there has been a attitudinal shift and improvement in grievance redressal. So via grievance redressal mechanism, this act is trying to bring a attitudinal change, and it is the priority of this act. Then apart from this act, we have a modernization of prison scheme. Then we have e-prison system, electronic prison system and digitalization. Then free legal aid via NALSA is another measure that we have taken. Then we have also brought concept of open jail. So in open jail, basically the prisoners who have showed a very good behavior and there are signs of improvement. So we segregate them out of that kind of a bad environment of the prison, and we basically um, it's a kind of bail, you can say, that they are released outside with certain restrictions and they are not kept in jail particularly. So this open jail concept focus on this reformation and not on retribution. So this is one of the major steps. Then in our CRPC there is a section 436A. CRPC, old CRPC had section 436A. Now this has been replaced by the section 479 of Bharatiya Nyaya Sanhita. So it says that if one third of punishment, whatever the time period of one third punishment is being spent in jail for a accused person, so that amounts to be automatic bail. So anyone who is under trial or an accused person, and suppose he did something which accounts to uh, imprisonment of 3 years, but he is still not convicted, and his court hearings are going on, and he's been in jail for around 1 year. So he has already completed one third of his punishment. So what will happen will there will be a automatic bail for this person. So he will be no longer kept in jail until unless the court gives a verdict on his case. Then there is also option for plea bargaining. So these are the issues with respect to prison, and these are the measures. Now some facts regarding this is in some cases which are important to know is that there was a case called as Sunil Batra case. So in Sunil Batra case, the court said that prisoners are entitled to all the fundamental rights. Then there was another case, Sheila Barse case. In this, Supreme Court said that there should be legal assistance provided to all the prisoners if they are not able to hire or bear the cost of an advocate or legal assistant. Then the legal assistance should be provided by the state. Then there is another case, not the case name is Hossain Ara Khatun case. It's a very famous case in which Supreme Court said that right to speedy trial is a fundamental right. So it states it states the responsibility of the state to ensure legal aid to underprivileged prisoners. Then there was a committee made under Amita Roy. So it was known as Amita Roy Committee. So what it said that there should be speedy trial. It focused that the prisoner to lawyer ratio must be one lawyer upon 30 prisoners. This is what the ideal ratio should be. And then it also said that there must be special courts also to dispose the case quickly and to ensure that justice is not delayed, because we all know that justice delayed is justice denied. Now let me revise for you the concept of open prison a bit more. So what is basically open prison? So in an open prison, the prisoner is not logged in to 24/7. So in traditional prison, the prisoner is in the prison for 24/7. is not allowed to uh, go outside. Then there is very strict supervision. But what happens in open prison, there is no provision for 24 into 7 jail. There is a provision for minimal supervision, not very strict supervision, and they are allowed to found some source of employment, so they can go out and can find some employment if there is available, which is not in the case of normal traditional prison. So basically, this open prison concept is based upon three principles. First is the self discipline, second is the minimal supervision, and the third is trust. So it is based on the humanistic psychology of mutual trust. But why did we had such provisions for open prison? So some of the reasons attributed to this is that there is a overcrowding of prisons, then the administration cost is very high, then uh, it also psychologically it also helps the person to bring in a reform within himself if he's been trusted and given an opportunity to prove that he can improve. So this is one of the reason. Now, what are the issues? So the issues are very generalistic issues are there. So if we see look at the issues, so what are the issues? There is lack of transparency, there is no codification, then the rich gets bail but the poor does not get bail. This is one of the issues. Then there are stringent provisions, so the new laws which have enacted, which have replaced the old CRPC and IPC, they have stringent provision like the proof of the burden of proof is on the person who is accused. He has to prove himself innocent. Then there are judicial discrepancies. Then there is we have seen in general that the Supreme Court's directives are not implemented, so there is no implementation of the Supreme Court guidelines. Then all such conditions uh, are proving to be a nuisance in our criminal justice system. With this, let me tell you a fact that about under trials. So, under trials, as per I have told you, as per NCRB data, there are 77% of prisoners which are under trial. Now, this is a huge number, but the question is why such a huge number? So, there is a high pendency of case. There is poor investigation by the police. There are arbitrary and indiscriminate arrest. Then there is lack of legal aid. On ground reality is this only. Sorry. Then there are issues with respect to bail provision. So the amount of bond which you have to uh, deposit to get a bail is high. It's not affordable for everyone. Then there is arbitrariness. There is no standard codification within the judiciary that in what terms and conditions a bail should be provided and should not be provided. It varies case to case. Again, this is one such provision that the poor gets the jail and the rich gets the bail. So this is the issue. So police force has also been in news for various reasons. So let us first note down some points. What are the issues with respect to the police force? So first issue is that there is a huge vacancy. There is a huge vacancy in the police force. So as per the UN guidelines, there must be 222 police officers per 1 lakh population. But if you'll see in India, so the sanction strength is around 195 officers on 100k population. But what is the reality? The reality is we only have 153 per 100k population. So there is a huge deviation in the idealistic number and in the reality, as well as in the sanctioned number and in the reality. So this is one of the issue. Then there is a resource constraint in the police force. So for example, talking about the West Bengal and Rajasthan, so they have shortage of weapons in almost 70% of police station. There is a shortage of weapon. Then the center state spending. So another issue is percentage of budget. So the center state combined spending is only 3% of the budget. So it is also a constraint in our police department. Then next one is this is said by the second ARC. In the second ARC report, it said that our police force follows a bottom bottom heavy approach. What do we mean by bottom heavy approach? That there are only 1% officers at the top level. Only 1% officers at the top level. Then there are 13% officers in the mid level, and below TI level there are 80 below ASI level there are 86%, which is the constable level. So our police force contains of 86% of people who are at the constable level only. So this is a very bottom heavy distribution of the police force. Then they don't the another issue is then they don't have segregation, they don't have separate functions. So what do I mean by that is the police is doing the law and order function, it is performing the law and order function, and it is also performing the investigation function. So this puts a double burden on the police force, and it also deteriorates the quality of the investigation by the police force. So if you'll see the practices in USA, they have a FBI for investigating. The police is performing the law and order functions, and for investigating they have FBI. Then there is lack of training in new offenses. So the police is not adequately trained for offenses happening in the digital world. Then there is also a trust deficit. So the second ARC says, it said because of corruption in police force, the inefficiency of police, and the unresponsiveness of the police, there is a trust deficit among the citizens with regard to police. Then if you'll see, out of the total budget which is allocated, out of the total funds which are allocated for the police forces, almost 84% of this is utilized in training, which is also not very adequate. But you see, 84,000 is utilized on training. Now that amounts to be around 9,000 per officer, if you'll see the average. So 9,000 per officer is what the amount has been sanctioned to train a policeman. So you see, this is a very very less number. 9,000 is very low, and this reflects in the poor training, and also in the factors impacting of factors affecting the mindset and increase of corruption inefficiencies. Then there are archaic laws. This is also one of the issues, that the Police Act of 1861, it is a colonial law which is still persisting. So it needs to be reformed, it needs to be changed. Then another sorry, another very serious issue is number of deaths in police custody. It is very high. So as per Ministry of Home Affairs, it is around 155 per year. So this is a high number, 155 death, and this is officially recorded. In many cases, we know that things are not recorded on paper. So now, what are some of the committees, some of the state governments' initiative to reform all these issues within the police force? So in this, we have important recommendations by the second ARC. What does the second ARC says? It says there is a need for attitudinal change. So the police force has to see itself not as police force but as police service. And now, how this will happen? This will happen via training, this will happen via skill upgradation. So, we need better training and better skill upgradation, and this attitudinal change should come in that the police force should not see it as a force but rather it should see it as a service to the society. Then, apart from ARC recommendation, state and central governments have also took some steps that states can bring in state police scheme. So the states can bring up states police scheme. What this can do? This can work on improving infrastructure. है ना? This can also try to increase the budget and the spending on the training of the officers. Then the Ministry of Home Affairs, it bought a Model Police Act. Now, what does this Model Police Act has? So it has provisions for, it has given provisions for functional autonomy to the states. Then there should be a merit based leadership. This is especially with respect to the appointment of high posts like uh, the post of DGP. Then there should be a security of tenure. This is also with respect to the posts like DGP. So DGPs are not given, matlab, they were earlier not given the complete tenure, so they didn't have a independence to go against some of the politicians if required at times. I hope you can understand what I'm trying to say. Then this act try to brings in accountability. Then it also tries to improve the service conditions. Then it is also setting up a police welfare bureau. It is also has provisions for setting up police welfare bureau, and it is trying to ensure the financial security and also the insurance of the police officer, as this is a riskier job. So with respect to police, there is a important case, that was Prakash Singh case. Now in Prakash Singh case, Supreme Court has given some directions. What are these directions? So the first direction is that the government should separate the functioning of the police. That means there should be a separate body for investigation, and the police should focus on law and order maintenance. These two, the dual role of the police should be ended. Then there should be a state security commission. Then another guideline of Supreme Court was that selection of DGP, as I told you, the selection of DGP should be on merit, and also he must be assured at least 2 years of tenure. We don't see many of the states following this direction, but This was a direction given by Supreme Court to ensure the independence of the DGP. Then, for the transfer purpose, to look into the transfer purpose, the Supreme Court directed that police there should be establishment of uh, police board for transfers to look into the matters of transfer. Then it also suggested for a national security commissions at the union level should also be made to bring in reforms. So this was about the police, and our prime minister also said that police force should be smart police force. So you can use this quote in the introduction that police force should be smart police force, as said by our prime minister Modi ji, है ना? And Modi ji also said that police force should be citizen centric. This is also reflecting the elements of the attitudinal change which the second ARC also talked about. So this was we have seen prisoners, then we have seen police. Now let us see another important aspect of this topic, that is the role of public prosecutor. Because public prosecutor also plays a very important role in the our criminal justice system. So what is basically a public prosecutor? So public prosecutor is a law officer chosen by state. So it is mentioned also under section 18 of our BNSS. So now what is the role? So in one of the famous case, that is Babu versus state of Kerala, in this case Supreme Court says that public prosecutor is the minister of justice, and it is duty bound, and his duty bound to assist court in delivery of justice. So Supreme Court says that public prosecutor is a minister of justice in some sense. Then its role is, so this we were discussing the role. So its role is also to investigate and involve with the police in investigation. Then another role is it has to protection of victim rights. He has to protect the rights of the victim. Then he has to assist in the courtroom's proceedings. Then he is also the legal advisor. He acts as a legal advisor. Then he helps the police in the filing of charge sheet in any case. Then he can also recommend the sentence to the court as per the seriousness of case, though that is not binding or something like that, but yeah, he can request. So he's a legal advisor, he's a assistant in the court proceedings. Then he's also a friend of the police in with respect to filing of the charge sheet in investigating process, and he's also the minister of justice as per the Supreme Court. Now how a public prosecutor is appointed? So just give me a second. So appointment, how a public prosecutor is appointed. So basically there is an eligibility criteria, that is a person should be 7 years of experience advocate. So to become a public prosecutor, a person need to be having 7 years of experience as an advocate. Now what is the procedure? So the district magistrate, this is not the DM, not the collector one, but the magistrate or the court, the district magistrate, he prepares a list of eligible advocates, and then he sends the list to the center or state as per the case. Then this list is then approved by the center or state, and the people are selected among them. So in certain situations, state can appoint. So this is one of the traditional methods, and there is also another door to become a public prosecutor, that the person, if there is a person with 10 years of experience in the judicial field, then in certain cases the state governments can appoint anyone with this experience as a public prosecutor. Baki, for majority of the cases, the district magistrate will make a list of the eligible candidates. He will send it to the state or center as the case may be, and the center or state will select among this list some names to become public prosecutor. Now, what are the issues with public prosecutor? What is the issue? So the issue is, first issue is in the appointment process itself. So there is in the appointment process, you can see that the district magistrate is just making a list, and out of this list the center and state will select, or they can reject this list and ask for another list. So there is no consultation mechanism with the judiciary itself in the appointment of public prosecutor. Like here only the center or the state is deciding. Here there is no involvement of the judiciary. So appointment in itself is an issue. Then within appointment there are cases, there is issue of arbitrary appointment. Now how, so in high profile cases, special public purpose prosecutor is appointed by state, which is highly politicized in nature. So this is another issue. This even you can write in the questions with respect to separation of powers. Then the police and public prosecutor are not working together efficiently in filing charge sheets. So this charge sheet issue. So basically the public prosecutor role is to deliver justice, but in most of the cases the police in a hurry to disperse its duty of filing a charge sheet, and in lot of cases you will hear that there were discrepancies and there were mistakes made by the police in filing this charge sheet. This is due to the conflict between the police versus the public prosecutor, and the police is in a hurry to dispose of its function of filing charge sheet, and in that hurry it sometimes just ignore the matter of the facts, the important facts of the case, and just file some charge sheet which is sometimes very irrelevant for the case and does not provides a strong case, and this hampers our judicial and legal criminal justice system also. Then another issue is that there is no accountability of this public prosecutor. Whether he wins the case, he loses the case, he is able to deliver the justice or not, whether he is working independently, whether he is working with utmost honesty, whether he is corrupt or not, there is no accountability mechanism. So suppose there is a poor guy, there is a rich guy. Now the public prosecutor is being allotted to this guy. Now this very rich guy can give him some bribe and he can intentionally lose the case, and this person who might be a victim will get the punishment. So this is injustice, this is utmost level of injustice. So what is the accountability mechanism here, that this person will be held accountable? There is no as such accountability mechanism. If this person is so poor that he can't even appeal in the upper courts also. So this is also a issue. Then there is no specialized training for the public prosecutor. So you see that the role of the public prosecutor is very serious in nature, but there is no training. So in appointment you just need a person with 7 years of experience, and whosoever among them can be elected as a public prosecutor. But before electing as a public prosecutor or after being elected as a public prosecutor, they are not being provided with training for this special role. So this is also an issue. And then the 14th Law Commission. So the 14th Law Commission has recommended that there should be a separate department of public prosecutor itself. So in order to bring the accountability, the transparency, the efficiency, there should be a independent department for appointing public prosecutor and for training public prosecutor. And this can also not just train public prosecutor but bring in accountability, and to avoid this corruption it can also bring in transparency. So this was the recommendation of the 14th Law Commission. So we have seen the role, we have seen the role of the public prosecutor, we have discussed the appointment process, we have discussed the issues. Now in way forward, we can write, as per the 14th Law Commission, there should be a separate department for public prosecutor, then specialized training should be given to them, then the appointment should be independent, the political influence must not be there, and there should be more involvement of the judiciary with respect to the consultation of the appointment. Then there should be meritocracy in the appointment of the public prosecutor. Then there should be a mechanism which can bring in accountability. Then we should also give some autonomy. So these 4-5 points you can write in way forward, and we are now moving on towards the next topic, the judiciary itself. Judiciary. So let us first discuss the role of judiciary. What is the role of judiciary? So the role of judiciary is to interpret laws. Its role is to administer justice. Its role is to settle disputes. It is also known as the watchdog of democracy. It is one of the pillars of our democratic country. Then the most important, it is the guardian of the constitution. Now there is a issue of underrepresentation of women in judiciary, and that is the topic which we will be discussing. Underrepresentation of women in judiciary. So the first fact is that till now we don't have any of the CGI, any of the women CGI. We have so many CGIs in the history. I think around 50 CGIs we have, more than 50, but no woman is yet appointed as a Chief Justice of India. Then after we got independence in 1947. From 1947 it took 1989 for us to get the first female Supreme Court judge, that was Fatima Bibi. So in 1981 for the first time we had a Supreme Court judge. Before that, for around how much? Around 30-40 years we didn't have a female Supreme Court judge. And currently one of our honorable Supreme Court Justice, Shri Hima Kohli. So she said that there exists a subconscious bias, and that is sidelining the women in judiciary. So this argument can be supported by the fact that the judges and the advocates, so only 15.3% of the advocates are women. And who are the judges? The judges are people who are advocates. They are elected from among the advocates only. So when we'll have only 15.3% of female advocates, then it will always lead to a funneling effect, that here we have 15.3%, and obviously at this stage where there should be Supreme Court judges, there will be obviously the less amount of female judges. So there is an underrepresentation, and there is a funneling effect. So there was also a Supreme Court's report, its report on the state of judiciary. That was the name of the report, state of judiciary. So it says that only 13% population judge are women. So only 13% are judge. Then from 1947 we only had 11 or 12 women as Supreme Court judges. So almost 77 years of independence, we had only 11 12 women as Supreme Court judges. So this is a huge concern. And if you see an example of the Patna High Court has only one women judge. And you see the health of the criminal justice system there. Now the question is that it is well established fact that there is an underrepresentation of women in judiciary. Now, why do we need women in judiciary? At first we must discuss that why we need women in judiciary. Is it necessary to have women in judiciary? So, as per our Article 14 and Article 15, there must be equality, there must be no discrimination. So, to be in line with our constitution, we need women judges. Now, there is also a patriarchal attitude. So, that is curtailing the participation of women in judiciary. We have to change this attitude, and to change this attitude in the society, we need women as judges. Another reason why we need women as judges is empathy. So empathy is required for reformative justice, and this might be a prejudice, but women in comparison to men at work are more empathetic. Then another very important reason for having women judges is women-centric approach to justice. So, for example, if there is a case of domestic violence, and there is a thing that there is a case of domestic violence, and the repercussions are not just physical, but they are also mental. And to understand the mentality and the sufferings at the mental level, it is not possible. It is not as much as effective for men to understand the situation and the circumstances through which a woman is suffering and going through. So a woman can only understand another woman better. So it is needed. And also for the fake ones also. So some of the women might misuse the provisions of domestic violence. To identify them also, a woman is betterly capable to identify a fake woman trying to mislead the code and trying to use these provisions in her favor. Then more women can obviously provide more access to justice. So basically, in the rural area and in the small towns, women hesitates to put up their case in front of a male judge. So if there are more female judges, so more women will come up to the judiciary, and hence it will increase the access of the judiciary also. So these are some of the reasons that why do we need women in judiciary. Now we have understood why we need women in judiciary. So now what are the barriers? What is stopping women from coming to judiciary? So the first barrier is the patriarchal mindset. Then another barrier is work life imbalance is there. Then the transfer policies. It is easy for the men to get transfer and shift his whole family to some other place, but for a woman it is unfortunately not as easy as the men. Then there is the judicial service role, requires a continuous practice. So women go through a phase of pregnancy for where they are not able to practice continuously for months, and then they also have to take care of the newborn baby and even the family also and of themselves also. So there they have to compromise with their practice, but the judicial service requires continuous practice. So this is also a issue. Then there is lack of crash facilities. This is also a issue. Then the retention and entry rate. The entry rate is very low. We have seen the funneling effect that only 13%, 15% women are advocates out of the total number of advocates. So this creates a funneling effect. Then what can be the solution with respect to this? So with respect to this, the solution could be, first is we need to bring reforms in our infrastructure. We need to have women centric chambers. We need to have women toilet, because I think around 20 or 25% of our courts do not have women toilets. Then we need to have creche facilities in our judicial uh, whatever the court or the judicial premises, in that we must have this facility. Then another solution can be, we can through government policies. So how from government policies we can give reservations to women. We can give reservation for women in judicial examinations also, and we can also give reservation at the lower judge post. We can have some reservation, some reserved seats for women only. So these are the steps which we can take. So we were discussing judiciary, and in judiciary we discussed that there is a underrepresentation of women in judiciary. Apart from this, uh, is there any another topic which we need to discuss? Yes, there is a very important topic, that is independence of the judiciary. Now why we need independent judiciary? Very simple, we need free and fair trial to have a check and balance, like the judiciary declared the election bond scheme unconstitutional in that way, to protect the constitution, to limit the power of the government, to give protection of the fundamental rights, to provide a basic structure, and to uphold the basic structure, to uphold the rule of law, है ना, to promote federalism, to bring to develop public trust, to have separation of power as mentioned in Article 50. For all these reasons, we need independent judiciary. But there is a concern. The concern is over independence. Over independent judiciary without accountability. This is a concern. What this will lead to? This will lead to over independent judiciary plus no accountability is equals to judicial despotism. So if there will be no accountability and over independence, there will be judicial despotism. Why I am saying this? Because there is a opaqueness in the appointment process of the judiciary. we are seeing that there is a decline in the accountability of the judiciary. You must have heard about the Justice Verma case, where a lot of money was found and still nothing significantly happened. Even the court has uh, barred the details of that case from the RTI. Then contempt of court is often used as a tool against freedom of speech. For example, we have seen this in the Prashant Bhushan case, where the freedom of speech was curbed through the contempt of court provision. Then there is judicial overreach or judicial activism. Also, we have incidents of increasing nepotism over meritocracy. So this is a threat in some ways to the judiciary. So therefore, we can say that one of our former Chief Justice of India, Justice Lodha, so he said that transparency is necessary in judicial appointment. So after seeing all these issues, one of the major questions is why we need reforms. Just give me a moment. I don't know why this is not working. Okay, so now our question is why we need reforms in appointment process. In appointment. So the answer is very simple. There is a first reason of why we need reform is there is high pendency of cases. So the pendency of cases is very high, and the percentage of pendency due to judicial vacancy alone is 30%. So 30% of the pendencies caused are just because of the judicial vacancy. And why there are judicial vacancies in High Court? It is because the appointment process there is a issue. There is always a tussle between the executive, that is the government, versus the judiciary in appointing High Court judges. So that is why we need reforms in appointment. Then the collegium system is opaque collegium system. It lacks transparency. It is oftenly said that there is a judge's uncle syndrome. No reason is being given for selecting a person. There are no there is no adequate and there is no transparent framework, and there is no basis of selecting a person as a judge, and the judiciary is not accountable. It cannot be held accountable to tell why they have selected a particular person, what are the merits. So there is no transparency in the collegium system. Then this leads to what? This leads to nepotism. This leads to chances of favoritism. I'm not saying this. This is mentioned in the book. I'm just telling you. This is not my opinion. Then what else? Only 11 to 12 female judges. Only 11 to 12 female judges in Supreme Court till now. So we need diversity, we need inclusivity, and hence we need a reform in the appointment process. Then another is to solve this tussle between the government versus judiciary. We need reforms, because what this causes, this waste time, this lead to wastage of talent, this lead to delay, this increases the cost burden. And you can see because of these delay there is 30% of vacancy, there is 30% of pendency because of this delay causing vacancies. And the last point can be the collegium system itself. It lacks women representation. So when the collegium itself lacks women representation, how can you hope that it will appoint more and more of women as judges when in itself it is not able to give adequate representation to women. Now, this we have catered the why we need reforms. Now, after knowing why we need reforms, the next big question is what reforms. वाई समझ में आ गया क्यों चाहिए, पर करना क्या है, अब क्यों चाहिए तो ठीक है. सो the first reform we need is there must be reforms in memorandum of procedure. So we must streamline the process of appointment so that there is no tussle between the government and the judiciary. Then we must have diversity in the collegium system. We must have women representation here. Then there is a limited number of candidates which are suggested to become judges. We need to expand the list of eligible candidates on the merit basis. Then another thing is, though the NJAC was declared unconstitutional by the Supreme Court, but I think there should be a NJC with judicial independence so that it can curb nepotism and favoritism chances. So basically, these are the reforms which are needed. Now, as we have discussed the reforms, the need for reforms, the issues of the judiciary, the underrepresentation of the women, let us also see if there is some other issue, because when we were discussing issues with respect to women, we have seen that there was some issue with respect to infrastructure. So let us discuss judicial infrastructure. What are the issues with judicial infrastructure? So there was a report, State of Judiciary report by Supreme Court. So State of Judiciary report by Supreme Court. So what does it say? Is that it says close to 25,000 district judges. There are close to 25,000 district judges, but there are only 4,250 courtrooms. So there is a discrepancy in the number of judges and in the number of courtrooms. So this tells us that there is a shortage of courtroom at the subordinate level. Then this report only tells that only 13% court premises have the crash facilities. Then only 50% of the judicial or the court premises have ramp facilities. Then 88% of the total have men's toilet. That means 12% of the court premises do not have even men's toilet, and for women it is 80%. That means around 20% courts are missing on women toilets. Then 60% courts only have power backup. So around 40% courts, they don't have power backup only. So if the electricity supply is cut, then the functioning is affected. Then only 5% courts have basic medical facilities. And only 5% have basic medical facilities. So this is a very serious issue which was given in the Supreme Court's report named as State of Judiciary report. Then is there any another issue also with infrastructure? So our ex-CGI, Justice D.Y. Chandrachud, so he said that there is a need for National Judiciary Infrastructure Authority. So what is the rationale behind having a national judiciary infrastructure authority? So the reason is because the per capita expenditure on the judiciary is rupees 182. It's very low. The amount of spending of the budget on judiciary is less than 1%. I'm sorry. So the amount of money spent from the budget on judiciary is less than 1%. Then even at the state level, no state is spending more than 1% on judiciary. So we see that there is a lower budget allocation. So therefore we need a national judiciary infrastructure authority. Moving to the next point, point number 3. There's lack of planning. Our approach is a reactive approach. We need proactive approach. So this is also one of the reasons why we need. This is also one of the issues with judiciary. Then there is a executive over dependence on executive for the finance for funding of infrastructure. Then centrally sponsored scheme for judicial infrastructure. In this, the states are not able to contribute effectively. So in efficient centrally sponsored schemes for judicial infrastructure, then there is a lack of coordination between the executive and the judiciary. So there is a lack of coordination between executive and judiciary. So this all tells us clearly that there is some issue. Now, what are the measures? What measures can be taken? Measures. What can be the measures? So the centrally sponsored scheme for judicial infrastructure needs reform. Oh my god, what is happening? The centrally sponsored scheme need reforms. Then there can be a e-court program. Then we can integrate AI in the judicial system. Then we can set up a fast track courts. Then we can make a judicial infrastructure development fund. वैसे it is already proposed but not yet being implemented. So this can be a measure. Then we can have a national mission for justice delivery and legal reform. This is also a nice way. And in way forward, you can write that we can have national judiciary infrastructure authority, and also at state level state judiciary infrastructure authority. So these are the way forward, and this you can also use in measures as what is need to be done. So our next topic of discussion is the regional branches of Supreme Court. So a standing committee of Rajya Sabha. So it suggested that there should be these regional branches of Supreme Court. And also in our constitution, article 130, there is a provision where benches of Supreme Court in various regions can be established as per the demand of the time. And So the standing committee of Rajya Sabha and our constitution both has provisions and suggestions with respect to regional bench of Supreme Court. Now, what would these regional benches do? So first, they will increase the reach. The reach will be increased. So how the reach will be increased? Uh, so many of our states do not have separate state courts. That means many of the states have common courts. So in those areas, especially in the northeastern area, if there will be a regional bench of Supreme Court, then the geographical reach will obviously increase. Then for a person from northeast, if he wants to file a case with the Supreme Court, an appeal in the Supreme Court, uh, the convenience will increase, and there will be reduction in the cost of justice. क्योंकि he earlier he has to come from suppose from Arunachal Pradesh or from Manipur to Delhi. Now he can get the access to Supreme Court in the northeastern region only somewhere. He has not. He will have some. What do we say? Um, he will have some ease in getting justice. Then the high pendencies will also reduce if there are more regional branches of Supreme Court. Then judicial accessibility will increase, and it will also lead to increase of social inclusivity. Sorry. Then our Article 39A, free legal aid and all those things of the DPSP, they will also get implemented and achieved in letter and spirit. Then there will also be promotion of regional languages. If there will be regional branches of Supreme Court, then obviously they will promote regional languages also in some ways. Now, what are the cons with respect to regional branches? Cons with respect to regional branches. What are the cons? So the number first is there are chances of legal inconsistency. So legal inconsistencies would develop, and it will lead to complex decisions. So basically, suppose if the one bench of the Supreme Court in Delhi on a matter is giving one verdict, and another Supreme Court bench with equivalent power is giving another verdict, so there will be a conflict, there will be inconsistency, and this will increase the complexity. Then there is chances of regional biasness. Then the dilution of authority, there would be a dilution of authority. Then one of the measures, one of the suggestion which comes is that instead of this we can have more high court. So in all those states which have common high courts, we can have separate high courts for each states. This can be a better option. Then another issue is there are financial and logistic challenges. So we have seen whether it's center or whether it's the state, the budget percentage allocation spent on judiciary and infrastructure is less than 1%. So there are all these concerns, and even the 10th Law Commission, it recommended that Supreme Courts can have specialized divisions rather than having regional branches to avoid all these cons. Then what can be the solution? Coming back to solution, we can have in solution we can write that at first we can have a national court of appeal. National court of appeal instead of having regional branches, and this National Court of Appeal would be within the Supreme Court itself, within the jurisdiction of Supreme Court. The second is we can increase the strength of Supreme Court. Then we can promote digital and e-governance reforms. So we can bring in e-governance, we can bring digitalization of the judicial process, which will increase transparency as well as accountability as well as accessibility, which is the most important point we're discussing here. Then the another solution is that the we have already discussed earlier also that national or state judicial infrastructure authority can be created, and it can be provided some autonomy to decide the finances and have some autonomy and independence in spendings, so it can decrease its dependence on the executive for funding. So ultimately what we are trying to say is judicial infrastructure in spending must improve. So these are the solutions. Now, as we have discussed a lot about the prison, the police, the public prosecutor, the judiciary, the issues in judiciary, underrepresentation of women, other issues regarding to the appointments, with respect to your infrastructure. So another one of the significant topics within judiciary is of judicial accountability. Judicial accountability. Now, what is accountability? So basically accountability is transparency plus responsibility plus answerability for actions. All these components added are known as accountability. And with accountability, always remember that independence, if given without accountability, it will lead to despotism. So now, while discussing this topic of judicial accountability, let us see what are the concerns. Why there have been questions on the accountability. First is around 6 crore. To be precise, it was around 5.4 crore few years back, but now it is, we can safely say it is around 6 crore. 6 crore pending cases. Then only 13% High Court judges have disclosed their assets. और इसका आप repercussions देख सकते हो in case of Justice Verma. A lot of cash was found from his house, and we haven't yet got any answers from the judiciary that where the cash came from and what are the merits of the case with respect to this Justice Verma. Then another concern is there are 1600 cases pending against judiciary itself. Against judiciary, it is also a concern. Why this is not getting solved? Why these are pending? Then another concern is out the judiciary is out of the RBI's ambit. Anything you will ask from the judiciary, not RBI, sorry, RTI, right to information. Anything you will ask from the judiciary, it is say that it is we cannot disclose the facts because it's in it can be a threat to the national security of the country if we are disclosing. So it is out of the ambit, out of the scope of RTI. So which is also a concern because it makes it very opaque. Then judges of both High Court as well as Supreme Court, they are not under the ambit of Lokpal. So these are some of the concerns with respect to the judiciary. So we were discussing accountability. We have seen these concerns. Now let us see why we require accountability. Why accountability is required? Let us first appreciate this fact: to build public trust in judicial system, to bring efficiency and reduce pendencies, reduce delays, prevent misuse of power, and also to bring in judicial reforms, to have a healthy criminal, efficient, effective, speedy criminal justice system. For all these things, we need accountability in judiciary. So, are there any provisions to ensure judicial accountability? Do we have any provisions? Yes, our constitution, article number 124, provides with the impeachment process of the judges. So this is one of the ways the judges can be held accountable. Then apart from this, we have the Judges Enquiry Act of 1968. It basically, the process of impeachment is given here only, in this act only. In article 124 only the provision is given. Then we have in-house mechanism, that is we have internal disciplinary inquiries also, uh, to ensure judicial accountability. Then the Supreme Court has said that the Supreme Court and High Court judges need to voluntarily declare their assets, declaration of assets. Apart from this, National Judicial Data Grid. This is also kind of uh, provision which is promoting judicial. Now let us look at what are the issues with these mechanism. So issues with these mechanism. So the impeachment process which we are having is very complex. It is very complex, it is very lengthy, and as a result, till date, no judge has been impeached in the history of India. Then, second, the in house mechanism, it lacks transparency, it is inadequate. So, the minutes of meetings is kept secret. There is no public disclosure of the minutes of the meeting. So, it is basically making the in-house mechanism very opaque and not as effective. Then there is no specification, no specific no specific investigation authority for the judicial accountability cases. So for financial crimes we have ED, for international crimes we have CBI, but for judicial investigations we have no as such specific authority. Then the disclosure of asset, it is voluntary, it should be mandatory. So only 13% of the judges have disclosed their assets, rest 87% they have not yet disclosed. Then the RTI provisions, it is very selective, the courts are very selective in with respect to giving uh, information with respect to the RTIs, है ना? So these are some issues. Now what can be the measures? What can be the measures? How can we improve this? So we can have some judicial standards, and a judicial standard and accountability bill can be passed, can be brought up at least for discussion in the parliament. Then judges can be brought under the Lokpal's ambit. Then there must be a judicial complaint commission. There must be a commission where uh, the citizens can complain, give their applications with regard to judicial misconduct. And also there can be mandatory asset disclosure. There need to be a transparency in the in-house disciplinary mechanism. and then there can be a judicial code of conduct and judicial code of ethics as well, to provide accountability, transparency, है ना. Then there needs to be protection of whistleblowers, so the safety of whistleblowers need to be ensured. So these are the measures which we can take to bring in accountability. So accountability, I've already told you, has three components: answerability, transparency, and enforcement. These three together comes in and forms accountability. Now, do you know the basic concept, the basic difference between accountability versus responsibility? So basically, responsibility is the the obligation to perform, है ना. And there cannot is it cannot be uh, no consequences. There are no consequences for actions. In responsibility, there are no consequences, है ना. And it cannot measure functions, and responsibilities can be shared. But accountability, it is not just merely obligation, but it is also answerability to the consequences. So suppose there is a job given to you, and you have now given this job to this person. So this person is responsible to do this, but not accountable. So there is an obligation to perform, but what if he performs it wrong? There is no consequence against him. There is no action for that thing against him. The consequence for that job, the action for their job, is with this guy. So this the guy with accountability, not the guy with responsibility. So when the job given to this person is being shared to another person, only responsibility is being shared. Accountability is not shared. Accountability is held by the original person who is supposed to do that particular job. So this is basically the difference between accountability and responsibility. So because we were discussing, so I thought I must tell you this. Now, why is accountability important? So we have studied a lot about judicial accountability and everything. Let us now see why it is important. So the first is curtailing the abuse of power. Then it promotes good governance. Then it increases public trust. Then it helps in curbing corruption. Then it acts as a check and balance. Then it improves the quality of delivery of services. Service delivery quality is improved. Then it leads to it promotes rational decision making. If there is accountability, you won't be taking arbitrary decisions, because you know that you will be held accountable for those decisions. So these are all the points which tells us that why accountability is important. Now, as we have discussed judicial accountability, let us discuss a very short topic of judicial activism. Now, what is judicial activism? So judicial activism is basically the proactive role of judiciary for the promotion of citizen, so for the protection of citizen, for protection of citizen, and to promote justice in society. So basically, it is a proactive role played by the judiciary to protect the citizens and promote justice in society. Now, what are the reasons for judicial activism? Reasons. Okay. Just give me a second. My pen is not working. Let me see why it's not working. Okay. Reasons. Reasons for judicial activism. What are the reasons? So, judicial independence is one of the reasons why we have judicial activism. Then, to fill the functional gap between executive and legislative, the judiciary has to play a proactive role. So, to fill the functional gap is also one of the reasons for judicial activism. Then, proactive proactive role of media in Indian democracy. Then to safeguard safeguard the citizens' rights. So for these purposes, there is judicial activism. And whenever there is a question on activism, you can write that judicial activism is a necessary evil and there has to be judicial restraint. Now, what are the tools of judicial activism? Tools. So, first is PIL, second is Article 142, which gives Supreme Court some powers. Then, provisions of judicial review under Article 13 and Article 32. Then, apart from this, judicial interpretations of some of the laws, some of the bills, some of the acts. So, all these are tools of judicial activism. Now, PIL under this is a important tool. So, let us see something with respect to PIL. PIL. So, if you see the data, no, around 25,000 PIL are filed every year, and in last 30 years, if you will see, last 30 years, more than 9 lakh PILs have been filed in Supreme Court alone. So, where did this PIL concept originated? So, the founding father of this concept were Justice Krishnan Iyer and Justice P.N. Bhagwati. So, basically, PIL is based on principle of locus standi. So basically, if anyone asks you what is a PIL, so you can say that it is a tool. It is a tool which works on the principle of locus standi, where any member of the public can initiate a proceeding on behalf of aggrieved members or a person who is unable to move to the court for justice. है ना? Then what is the importance of PIL? So it increases the access to justice. It is a tool to put forward the voices of the vulnerable section. Then it lead to protection of basic human rights. Then it also leads to democratization of justice. Then it increases trust on judiciary. Now, what are the issues of PIL? So it increases the burden of judiciary. Very frivolous and vague slash frivolous cases are filed under this. Then it deflects the courts from serious matter. It is used as tool for politicization, publicity, and oftenly this public interest litigation is also used as private interest litigation. So, what can be the measures? One of the important measures was that we had a national litigation policy. So, in many of the cases, no, the government is also uh, a litigant in majority of cases. So, to use this power, the power for this litigation. So this policy says that the government should be a responsible litigant. So it brings in aspects of responsibilities. So leave this for right now. We will discuss this in brief sometime. Let us now discuss what are the measures, what we need to do. So with respect to PIL, we need to verify the credentials of petitioner before admitting or accepting the PIL. Then we need to look in the merit of the case, that is it a genuine case of public interest or is it a case of private or political interest. Then there should be fines on vague and frivolous petitions. For example, Juhi Chawla was fined for filing a PIL when in with respect to that 5G towers. So basically, you must have seen in news that she filed a PIL stating that these 5G towers uh, will I don't remember what exactly was that case, but it was something related with birds, that it will impact birds somehow. And the PIL was not backed by any scientific evidence, any report, no rationale. There was seriously, it was a baseless report. So she just said that this 5G tower will impact the bird. It is dangerous for birds, and hence there should be no 5G towers. And this argument was backed by no study, no report, no scientific observation, nothing. So the court fined her. So this should happen more to avoid frivolous and vague petitions. Then, apart from the petitioner verification, there should be a content verification also, a content verification of the matter presented in the PIL. Then media, the role of media. Media must discourage such frivolous petitions, because the uh, news channels and in today's world the social media, at that time when the Juhi Chawla brought this PIL into the Supreme Court, the media promoted this thing a lot. And you know what the WhatsApp University does. So without any scientific study or without any argument, the WhatsApp University spreaded many rumors with respect to this 5G tower. So the media's role is crucial. The media should discourage such vague and frivolous petitions. So yeah, that's for this topic. We have seen tool of the PIL as a tool of judicial activism. We have seen the concepts of accountability, responsibility, importance of accountability. We have seen the judicial accountability, what are the concerns, why we need it, what are the provisions, what are the issues, what are the measures. Then before it, we have also discussed about the regional branches of Supreme Court, the provisions, the pros, the cons, the way forwards, the solution. Then before it, we have also discussed the appointment process, what is the appointment process, why do we need reform, what reforms we need, what are the issues in the judicial infrastructure, what are the measures that we can take. And before that we have also seen the topics of underrepresentation of women in judiciary, and why there is underrepresentation, and what can be some of the measures, what are the benefits of having women, more number of women in judiciary, है ना. Then before it we have also seen the role of public prosecutor, the issues with respect to the appointment of public prosecutor, some of the way forwards. And we have also seen the topic of police, what is currently the police force, the percentage of budget spending, the issues with respect to training, with respect to vacancies, with respect to attitude, with respect to the distribution, that is the bottom heavy police force. Then we have seen what are the financial issues, what are the social issues, and then we have also seen some of the cases. And then we have also seen Ministry of Home Affairs Model Police Act for the betterment and for the improvement of all those issues. We have seen the recommendation of second ARC. Then before police force we have also seen the prison, the issues with respect to prison, the measures we need with respect to prison, some of the cases with respect to prison, and also the uh, concept of open jail and proper prison. So we have discussed enough of topics of GS2. Now another topic which we will discuss next is explicitly mentioned in the syllabus, and it is separation of power. So separation of power, so the concept was given by Montesquieu. He said that excessive concentration of power will lead to tyranny and despotism. So basically, he gave three principles of separation of power. The first principle is that one person should not be part of more than one organization. So one person should not be part of more than one organization. So this is the first principle. Then one organization should not exercise function which is assigned to another organization. So this interference of functions should be not be there. Then the third one is directly it is saying that one organization should not interfere in another's function. So here it was talking about not exercising the function assigned to others, and here it is talking about non-interference. So the principle of non-interference, the principle of not exercising authority over others' function, and the principle of one person not part of more than one organization. So these three are the principles given by Montesquieu in his theory of separation of power. Now, why do we need separation of power? What is the need for separation of power? To avoid tyranny, to avoid despotism, and separation of power will lead to specification. This will further lead to increased efficiency. Then, if there will be separation of power, there will be accountability. The accountability will be high. Then there will be constitutionalism, because it will protect the liberty of the people. So hence we can say that there will be constitutionalism if there is separation of power. So are there any provisions in India for separation of power? Yes, there is Article 50 DPSP which states strict separation of power. Then there is Article 122 and 212. So basically these prohibits court from inquiring validity of procedure of legislature, है ना, except for constitutional or judicial scrutiny. And in the similar way, Article 121 says that Legislature cannot discuss the conduct of High Court and Supreme Court until there is an impeachment motion. So Article 121, 122 and 220, 212, 212, these three articles, they are providing a provisions for separation of power. Article 15 is providing provision for separation of power. Then if these articles, the constitution is providing the provision for separation of power, then what is the issue? The issue is this separation of power leads to delay. There is a policy paralysis. There is chance of reduced or no accountability. As there is a strict separation, one organization will concentrate all the power. There will be no checks and balance, and the organ will become despotic. So the ultimatum with respect to this topic is that there should be functional autonomy, but there is also a need for collaboration for efficient functioning and accountability. So this can be a way forward, that we need to provide functional autonomy, but there is also a need for effective collaboration for efficiency and accountability. So now let us discuss various topics within Parliament where we'll use this concept of even the separation of power also. So let us start from a new topic, which is very important topic of GS2, that is the Parliament. So starting with Parliament now. So before discussing the role, issues and various other topics, I would like to quote Sardar Vallabhbhai Patel. He said, "A strong parliament is essential for a strong nation. It must represent the will of the people and act with unity for national interest." Okay, now let us discuss the role of parliament. What is the role of parliament? It is the bedrock for rule of law. Then it is democracy in action, not just in words or not just on a paper. Then obviously the most important one is lawmaking functions. Then parliament's role is also to ensure executives accountability, for example by no confidence motion. Then another important function is passing of the annual financial statement, that is the budget. Then parliament is also electing the president and vice president of the nation. Then it is the platform for debates and discussion, and it is also a platform for the voice of the vulnerable, the voices of various diverse sections. It promotes federalism in India, and also it keeps a check on the judiciary also. You can also write that also. Apart from this also there are various other roles of parliament, but these are enough if you can remember them. Now what are the issues with respect to your parliament? Side by side I'll also be discussing the issues if there are similar issues in state legislative assembly also. So firstly, that there is no substantive role of Rajya Sabha. Then 80% of our budget is passed without discussion, that is known as guillotining of budget. Then if we'll compare the numbers of bill passed, so in the first Lok Sabha almost 333 bills were passed, whereas in the last 17th Lok Sabha only 227 bill were passed. So you can see a decline of around 106. Then there is a declining productivity. Why declining productivity? One of the major reasons is very less sittings. So in 2024 there were only 55 sittings. Then the post of deputy speaker is mentioned in article 93, but few days back a report came which told that around more than 1000 days this post of deputy speaker, this was vacant, this was not elected. So there is a convention that the deputy speaker is elected from the opposition party and not from the ruling party. So not having a deputy speaker is a issue, because then the opposition becomes even more weaker, and for democracy you need a stronger oppositions. Then if we'll see one of the major issue with respect to state legislative assembly. So if we'll see the annual average sittings of the state legislative assembly, so we are comparing the 27 data with 2024 data. So in average annual sittings in 2017 were 28 days, just 28 days. Now it's even worse. It has come down to just 20 days. Then in this, budgetary discussions are only held for 7 days, 7 days only. Then number of bill passed in 2024, if you will see the data, bill passed in 2024, there is huge variation within India. In Delhi, only one bill was passed, whereas in Tamil Nadu, 45 bills were passed. This can also be attributed to the role of governor, but ultimately it is the issue with respect to state legislative assembly. Now in 2024, one another fact was that 51% of the bills, they were passed on same day and without discussion, and the average sitting was around 5 hours, 5 hours per day. So this is very less. So these are the issues with respect to parliament and also with respect to state legislative assembly. Now, what has been the reason for this decline? Reason for decline. So the number one reason for decline is underperforming or weakened, or you can say fragmented opposition. Opposition, weak opposition is one of the reasons. Then there is criminalization of politics, that is, according to ARC report, 46% of MPs, they are accused criminals, and majority of them have serious cases against them, like murder, half murder, rape, kidnapping, all those. Then another reason is, as per second ARC only, there is lack of effective training of our lawmakers. Then there is a politicization of the post of speaker. Then there is declining role of individual MPs. You might have seen that in 2024 many of the Rajya Sabha MPs were suspended. Then apart from this, another reason is frequent election in India. So every year in 3-4 states there is state election. Then within state election there is panchayat elections and municipality election. So mayor's election. So each year the year is tightly packed, tightly scheduled, and some elections are going on in some part of India. So this is also a reason. The majority of the political parties and their elected candidates, MP and MLAs, are busy in the elections only. Then what are the suggestions कि इसको कैसे ठीक कर सकते हैं? So there was a committee, National Commission on, just let me recall it. It was I think it was National Commission or National Committee for Reviewing the Working of Constitution. NCRWC. Okay, so this committee suggested something. So it suggests number one, that there should be mandatory minimum sittings. In Parliament, it should be around 120 days annually, and in state legislatures, it should be 60 days annually. This has to be the minimum standard set mandatorily. Then there should be pre-legislative scrutiny. Then there should be research support provided to our lawmakers. Then there must be a code of conduct and code of ethics for our MPs and MLAs. Then there should be strengthening of parliamentary committee system. Then there should be promotion of intra-party democracy. Then the election of deputy speaker should be time bound. It should not happen that for around more than 1,000 days there is no deputy speaker in the parliament. है ना? So these are the measures suggested. Now, when we were discussing the reasons of these issues with respect to parliament, we have seen that one of the issues was criminalization of politics. Criminalization of politics. So let us discuss this issue in a bit more depth. So, criminalization of politics. So, what is basically criminalization of politics? So, one of our former CGI, Justice Deepak Mishra, he said criminalization of politics is akin to a termite to the citadel of democracy. Also, Honorable APJ Abdul Kalam said, unless we remove corruption and criminalization in politics, we cannot dream of developed India. So, I'll give you one fact that as per the ADR report, one of the ADR reports says that 251 newly elected MPs in the Lok Sabha this time are facing criminal charges. Then this report also mentions that in the state legislative assemblies, around 45% MLA have criminal cases against them. And in total in India, around 5,000 cases in the courts are pending against lawmakers only. Now, what is the reason why this phenomena is taking place? Why is this criminalization of politics so popular? So, let us discuss the reasons why there is a criminalization of politics. One reason, as per ADR report, is that person with criminal backgrounds have high winnability. So they have the muscle power with themselves. Apart from money, they are using the muscle power to gather votes in their favor. है ना? Then there is a voter apathy. Voter apathy is also there. So in India, the politics and the vote bank is based on caste and religion. So somewhere it overpowers the criminal record of the candidate. So when a person is deciding to cast his vote, he does not review and look at the criminal background of the candidate. And despite of looking at the criminal record, he sees his caste and religion as a basis to give him vote or not. So voter apathy is also one of the reasons why there is criminalization of politics. Then another reason is there is lack of legal and judicial framework. So there has been some judicial framework and legal framework, but it has been inadequate legal and judicial framework. Then there is a weak political will. Now you have seen 46% of our MPs are accused in criminal charges. So will they want to bring in a reform which will take people with criminal charges and criminal background out of politics? They won't. So there is a weak political will, and there is also political patronage. Then another issue is opaque election funding. Opaque funding. This is also one of the issues. Now, all these reasons, how are they impacting? Let us see that. So, what is the impact of these? Impact is declining parliamentary function, poor parliamentary function. Then there is policy paralysis. Then there is erosion of democratic value. How it is eroded? That there is no free and fair election. There is culture of violence, because when you give tickets to the mafias, to the so-called bahubalis, then there is a culture of violence. When there is a culture of violence and the lawmakers are criminals, there is decline in conviction rate. there is a decline in conviction rate, then there is no accountability against them, and then there is very, very high corruption. So all these lead to erosion of democratic value. Apart from this, the youth gets disengaged, discouraged. So the youth disengagement from politics is also a major impact. Then voter turnout ratio is very low. When people will believe that their vote doesn't matter, ultimately the criminals are going to win the election and rule them. Or even if they are trying to vote and they are getting threatened for not voting in favor of criminal, so they choose not to vote better than going and voting for someone else other than the criminal. And sometimes even they don't have choices also. When both the parties, all the parties which are contesting for a particular seat, they all are giving tickets to criminals. So ultimately you have one seat, and you have five criminals contesting for it. Now whomsoever you give the vote, ultimately you will be ruled by a criminal only. So it's better not to give the vote. So it discourages the voter, and hence it will lead to decrease in the voter turnout ratio. Then what are the steps now? Now let us look at steps. So this we have seen the phenomena, and here we have seen what is the impact. Now how we have and how we can reform it. Now let us look at the steps. So legislative steps, let us look at legislative step. So we have section 8 subclause 3 of the RPA Act 1951. So any person accused in a criminal case, when he is convicted and given punishment, that is imprisonment for more than 2 years, then he is automatically his membership in the house of whether Lok Sabha, Vidhan Sabha, or state legislative assembly or any house, that membership will get terminated. And after completing his term of imprisonment and the punishment, for the next 6 year also he cannot contest election. So this is a legislative step to decriminalize the politics in India. Then let us look at the judicial reforms. Has judiciary done anything? Yes, it has done something. So in ADR versus Union of India case, so judiciary said it is compulsory for political parties to disclose cases which are against their candidates. Then another case is PIL versus Union of India case. In this, the Supreme Court directed that the political parties and the candidates should post their information, their background on the social media. Also, the judicially struck down the section 8 by 4 of the RPA Act 1951 in the Lily Thomas case. So basically, this used to give liberty to the criminal. So currently, if someone is booked under section 8 by 3, he is gone out from the house. But suppose if there is a condition when someone is convicted in a lower court and he appeals in higher court, and then he says that I have appealed in the higher court, my case is pending, it's not, the judgment has not yet arrived, so he will be allowed to continue in the house. So this section 8 subclause 4 was exactly this. It gave a kind of loophole to the criminals. So if they were convicted from one court, they can appeal to another court within a limited time period, and they can stay as MPs and MLAs, because appealing in the upper court and then again reaching to a decision takes time. We have already seen what is the pendency of cases in India, around 6 crores. So they'll continue to be MPs and MLAs, and they'll finish their terms also. So the Supreme Court struck down this. Then Election Commission. Has Election Commission of India did something for this? So yes, they have a KYC app. So this KYC app is Know Your Candidate app. In this app, you can get all the details about your candidate. Then the ECI is also using social media as a tool to promote awareness, to increase a voter percentage ratio. And I'm forgetting one more initiative of ECI. I think this the KYC app only, or some another app also it has made to register complaints with respect to any discrepancies during the model code of conduct also. So that is also a good step. But for now, leave it. Just let's confine it with these two statements only, and that provision I'll tell you later. Then, as per second ARC has also given some this thing suggestions. So it says that there should be a permanent ban on politicians with conviction in cases. So they are not giving this temporary ban which is provided in the section 8 subclause 3 of the RPA. Rather, they are emphasizing on a permanent ban. Apart from this, ECI has also suggested reform in funding of election. So there was opaqueness with respect to funding of election. So ECI has also suggested transparency with regard to funding of election. And if you further, if I'll stretch this one, in election funding, Supreme Court also declared unconstitutional and illegal and struck down the electoral funding scheme. So this is also a measure. We'll discuss all this thing in depth in the later part of this video. So this is we are done from for this topic of criminalization of politics. So you can, whenever there is a question on criminalization of politics, you can write some quotes like Mahatma Gandhi ji said that politics without principle is a sin. Then criminalization of politics leads to the decline of parliamentary functioning. And Bhanu Pratap Mehta, he is a political scientist, he said this decline of parliament is not just about the quality of debate, it's about loss of its ability to be a credible forum for the expression of popular will. Then Modi ji also said that Lok Sabha is temple of democracy. Then Nehru ji said the Lok Sabha is the supreme representative body of the people. So there must be values, because values will decide your ethics and your ethics will guide your action. So there must be some values. Okay, so we have discussed one of the issues, criminalization of politics. And when we were discussing the issues with respect to parliament, we have seen that the substantive role of Raj Sabha was also one of the issues. So now let us discuss something about Rajya Sabha also. Rajya Sabha. I don't know why my stylus is not working. So the Rajya Sabha, or the Council of State, it is established under Article 79 of the Indian Constitution. So the founding forefather of the Constitution and a very important freedom fighter, Mr. B.R. Ambedkar, he said that Raj Sabha is not a rival but a friend, guide and mentor of Lok Sabha. And our former first PM Nehru ji, he also said that Raj Sabha represents state and it is an important link in federal structure of state. So what is basically the role of Raj Sabha? Okay, now let us discuss the role of Raj Sabha. So it keeps a check and balance on Lok Sabha. So, for example, the right to fair compensation and transparency in land acquisition, rehabilitation, and Resettlement Act 2013. So, this bill was passed by Lok Sabha, but the Raj Sabha, it suggested some important provisions, and due to which these provisions were then inculcated in the bill. Then deliberation of national issues and ensures accountability So accountability is ensures via question hour. So then another role of Rajya Sabha is it is platform for eminent person from various field, like we have Sachin Tendulkar also as a member of Rajya Sabha. So this is also one role. Then it upholds the federal structure of the nation. It has, for example, it had played a proactive role in the GST implementation. Then it prohibits uh, hasty and quick legislations by reviewing the bills and policies of the government. And then it also has some special powers like Article 312, which states about all India services. Then Article 249, which is the power of the parliament to legislate on the state list. Then for the approval of proclamation of emergency in absence of Lok Sabha is being provided by Raj Sabha only. So these are the major powers of the Raj Sabha. Now, what are the issues with respect to Raj Sabha? Just give me a second. So the issues with respect to Raj Sabha. So earlier there used to be a domicile criteria which is now been removed. So domicile criteria is basically the person which is getting elected from a Raj Sabha seat must be domicile of that particular state. But now this provision is being removed, and people, suppose a person from who is having a strong political connection, and suppose he's from Delhi and he's getting elected on a Rajya Sabha seat from Maharashtra. Now, how would he be able to represent Maharashtra, or a person from Rajasthan getting represented as a Rajya Sabha member from northeastern states? Will he be able to cater and fulfill the demands of those states not as efficiently as a person from that various domicile would have been done, who would have been? So this domicile criteria is removed, and it is affecting the state's voice and also the representation, है ना? Then voting, there is a voting issue. So voting takes place via open ballot system. So in Kuldeep Nagar case, no, Supreme Court judgment said that cross voting won't attract the 10th schedule provision, which in itself is in contradictory with Supreme Court's other decision, where it has said that cross voting will amount to anti-defection. So this is also one of the issue. Then Raj Sabha is often sidelined by the use of money bill. So GST was implemented as a money bill where they sidelined the Rajya Sabha. Then there is low attendance, and there is a limited power of Rajya Sabha with respect to bills. In case of money bills, it can't deny. And also with respect to other bills, also it has mostly it has delaying powers and not denying powers. Then, even in the cases of joint sittings, Raj Sabha has no majority. There are more number of MPs from Lok Sabha, and hence the Raj Sabha is technically bypassed in joint sittings. Then, no confidence motion is only limited to Lok Sabha. Raj Sabha has no such powers. Then Raj Sabha has also seen a declining trend in the debates and discussions. And also, Rajya Sabha is basically used as a backdoor entry for politicians who are not able to win elections via contesting directly in Lok Sabha election. So they use this as a backdoor. People who contest election and get a defeat, they use this gate to enter the building of the uh, parliament. Just give me a moment. Okay, then what are the measures? So we have seen the rule, we have seen the issue now. What can be the measures? Measures can be reintroduction of the domicile criteria. Then there should be minimum mandatory 100 days of independence in Rajya Sabha. Then political parties should have intra-party democracy. Then there must be enough and healthy debate and constructive criticism of the government. Now we we are focusing so much on this intra-party democracy. Let us look at what is the issue with this. So the number one issue with intra-party democracy is that there is over centralization, of power in political parties. Then another issue is that constitution of the political party often promotes high command culture. Then are not regularly held. Elections are not regularly held within the parties. Then there is no role of Election Commission of India in the voting process of the election of party only. Then these parties are excluded from the Right to Information Act. So there are issues with respect to transparency, and especially transparency issues with respect to funding sources. On then on every decision there is a compulsory whip, mandatory whip issue. This is also a issue. Then the distribution of ticket is basically the function of winnability, and winnability is high for criminals. So again this lead to criminalization of politics. Therefore we need intra-party democracy. So what are the reforms needed? Now reforms can be increase women participation, then increase or attract the youth with talent, increase their engagement, then enhance election commission of India's role, its domain should be expanded. Then democratic intra-party politics should be there, that the government should be democratic as well as the society should be democratic. Then there should be increased accountability. Then there should be democratic decentralization also. So these are the reforms which are needed with respect to our intra-party politics. Okay, so here we are done with the parliament. Now let us see a topic which is related to parliament, that is the parliamentary committee. So parliamentary committees are of two type. One is standing, one is ad hoc. For example, standing may you have financial standing committee, then you have department related standing committees. In ad hoc you have inquiry committee, you have advisory committee. Now what is basically the role of these committee? So the role of these committee is detailed scrutiny of bill. So Pranab Mukherjee once said that parliamentary committees are like mini legislator. They do detailed scrutiny of law and ensures accountability of government. Then parliamentary committees are also instrument in enhancing efficiency and expertise of our legislative process. They also act as a deliberate mechanism to solve complex issues, to examine complex issue. And as per B.R. Ambedkar, they are the backbone of our legislative process. They focus on consensus building with respect to various important issues. They also promote cooperative federalism, and they also use the analysis of the reports of CAG, which brings in transparency in the government. So the laws, the policies, the budgets are analyzed, are debated, are discussed, and are also investigated. And this needs efficiency, this needs effectiveness, this needs accountability, this needs consensus building, and all this is provided by parliamentary committees. But then what is the issue with respect to parliamentary committee? So if you'll see 15th Lok Sabha and compare it with 17th Lok Sabha, in 15th Lok Sabha 71% bills were referred to parliamentary committee, whereas in 17th Lok Sabha only 16% bill were referred to parliamentary committee. So the number has drastically fallen. Then number of sittings here also in the parliamentary committee has reduced, and which has led to a 25% decline in the productivity of these committees. Then the time frame given for the discussion to these committee is very less. For example, in BNS, the time frame to discuss such a elaborate act, the time frame was very less. Then there is again issues of poor attendance within the parliamentary committees. Then the parliamentary committees lacks research staff. They don't have adequate research staff. Then their role is confined mostly to uh, post mortem. So majority of their works which they do, like analyzing the spendings of the government, so the spending has already been done. Now if you are analyzing it and telling that this has not been the spendings were not as efficient as they could have been, now what's the point? The spending has already been done. So mostly their work is of post-mortem nature. Then there is again party politics within the parliamentary committees also. So how can we improve all these things? So there were some reforms suggested by RNCR RWC, National Commission for Review of Working on Constitution. So it said increase the number of parliamentary committee, especially the departmentally standing committees. Then increase number of sittings. Then it also recommended that its scope can be widened, broadened up, and also provisions of pre-investigation and pre-investigation powers can be given to these committees. So their work is not of post-mortem nature, but they can do pre-investigation also. Then they should we must increase the summon powers of the parliamentary committee. Then there must be effective representation of all the political parties in this parliamentary committee. There should not be politicization of these committees. Then research and support grant should be given, and the government should support also with expertise. Then the tenure is currently of 1 year per parliamentary committee. This is very less time. 1 year so it takes to understand the functioning and investigating all the things. So the tenure must be increased to 3 years at least, so that they get enough time to not only investigate but also bring in reforms also. So these are the various aspects related with parliamentary committee. Now next topic of our discussion is related to one of the part of the parliament itself, but not the legislative or executive part, but the president. So we will be discussing the ordinance. So ordinance powers. So Article 123 of our Constitution provides that the President has the power to promulgate ordinance when there is a requirement of immediate action, and either of the house is not in session. Only in such conditions the President can promulgate ordinance. Now, what is the need for ordinance? So it helps us deal with emergency situations, है ना? It helps us prevent constitutional and governance vacuum. It also ensures continuity in governance. Now we have seen that in past years that there has been a rise in number of ordinance passed. So what have been the reason for this rise? Reason is a coalition government. So in coalition government there is lack of consensus building. There is difficulty in consensus building. So coalition in coalition government, ordinance is a way through which we can bypass the legislative process of building the consensus and uh, do what is required at the present condition. Then it is also used as a tool to overcome the House of Council, because sometimes the parties do not have majority in Rajya Sabha. So, in order to overcome that majority deficit, they use ordinance, because most of the times this is used as a political tool only. Then it is provision for emergency situations like COVID-19. In such conditions, both the houses were not able to uh, sit together. In those conditions, provisions like this is on the only solution. Then there is a frequent electoral cycle also, that has also been attributed as a reason for rise in the number of ordinance issued. Then what is the issue? अच्छा चलो अगर हो भी रहे हैं इतने सारे ऑर्डिनेंस इशू, तो इनके साथ इशू क्या है? What is the issue? They bypass legislation. They violate the concept, the principle of separation of power, and hence they violate Article 50 of the Indian Constitution. Then it also suppress the role of the opposition parties. Then it creates concentration of power. It does not provides for accountability, and power and independence without accountability leads to despotism. So it creates despotic nature. Then obviously there is a when there is despotism, it also has centralization of power. So these are basically the issues with ordinance. Now there are some judgments by the Supreme Court which gives some kind of guidelines with respect to ordinance power. So in the DC Vadwa case, the Supreme Court said that ordinance is a tool of exceptional circumstances, and so it says that it is a tool of exceptional circumstances, and that a repromulgation is unconstitutional. So if an ordinance is promulgated and then it is not accepted by both the house, you cannot repromulgate it. It is unconstitutional. Then in RC Cooper case, Supreme Court said that ordinance making power is under judicial review. So the ordinance making power is under judicial review. Then in a recent another case, the Krishna Kumar case versus State of Bihar. Again, the Supreme Court said that repromulgation is unconstitutional. It is a fraud on constitution and against the constitutional morality. So these were some of the judgments with respect to ordinance and ordinance making power. Now let us move towards another important topic of our syllabus of GS-2, which is pressure groups. Pressure groups. Now what are these pressure groups? These basically, a pressure group is an organized group which seeks to influence the government policies, or you can say it tries to promote or defend the common interest of the group and the public against the government policies. So we have many examples of pressure groups in India, like India against corruption. It was a pressure group. It led to the formation of Lokpal. Then we had Mazdoor Kisan Shakti Sangathan. It led to the RTI Act. So these are two examples you can always mention: the India against corruption leading to Lokpal, and the Mazdoor Kisan Shakti Sangathan leading to passing of Right to Information Act. So what are the basically the tools used by these pressure group? What are the tools? How do they influence? What do they exactly do? So first tool is litigation. Through litigation they defend the common interest. Then there is also tools like direct action. So direct action like boycott, direct action like protest. Then they also do lobbying, they also do advocacy, they also do electioneering, they also do awareness and public related campaigns. So these are basically the tools. Now, what are the positives of all these things? The positive are they act as a safety valve. So you must have seen in history also the revolt of 1958 and then the formation of Congress. So the Britishers have stated that they see the Congress as a safety valve. So another positive is direct accountability is ensured. Then it is a form of participatory democracy where the citizen participation is seen. Then it keeps a checks and balance. Then it is a tool for grievance redressal and also for policy inputs by the public. Then it gives the voice to the voiceless. Then it acts as a feedback mechanism. So these are all the positives. And we have seen that recently there has been a rise in these pressure groups. So why there has been a rise? Because our grievance redressal mechanism has been deteriorating and it has been poor. Then the parliamentary function we have seen is on a decline. Then the rights of awareness of rights is very less. And also there is a rise of social media, which is one of the major reasons for increase in the rise of pressure groups. But we have seen the role, the tools, the positives, and the increase of the pressure groups. But is there anything negative with respect to this increase? Yes, there are some issues with respect to pressure groups also. Their perspective is sometimes very narrow perspective, driven by good of a very narrow range of people, or very narrow interest, narrow with the benefit of a very narrow group. और उसके पीछे क्या होता है कि जो लार्जर बेनिफिट है वो नहीं हो पाता है. Then sometimes they also turn violent. Then there is no accountability of these pressure group. Then one of the tool, that is lobbying, which they were using, this lobbying can lead to crony capitalism. This often leads to crony capitalism. So this is very dangerous for our economy also and for our polity also. Then they can act as tyrants of minority. So they act as tyrants of minority. So these are some issues. So B.R. Ambedkar has given three warning signs uh, for democracy. One was violent protest, which is a issue here. Then political democracy over social democracy. This is also seen in the issues we discussed with respect to the pressure groups. So out of two signs of warnings with respect to political democracy given by B.R. Ambedkar are present in the pressure groups. So, what is the way forward? What do we need? So, the pressure groups, there should be a mechanism for them to be held accountable we must ensure that the pressure groups are non-violent. The pressure groups should be regulated under some acts, policies, or mechanism. And till date, there has no. I have not yet got some committee or some report with respect to pressure groups. But whenever I'll get it, I'll update it here. Okay, so this topic is done, but no, not yet done. So sometimes you have seen that for farmers there are various pressure groups, agricultural related pressure groups, which have impacted the MSP policy, which have impacted various other electric and water subsidies, and these policies, these pressure groups have also played a crucial role in freebies. So let us discuss freebies also. Freebies. Now, what is freebies? So, freebies is basically the amount, the monetary benefit which the government is giving in lieu of no work, and sometimes also the services which we are taking from the government, they are provided to us without cost. That is also a part of freebie only. So Supreme Court in one of its judgment in Supreme Court in S Balaji versus State of Tamil Nadu, the Supreme Court says that election manifesto promises do not amount to corrupt practices under Section 123 of RPA. So, this is the decision from where a loophole is created and freebies are given just before election. Now, what are the pros of these freebies? तो दे रहे हैं तो ठीक है, इसका प्रोज क्या है, क्यों दे रहे हैं? So it fulfills the basic needs like free food grains, free education, है ना? So these are considered as good freebies. The issue is with respect to bad freebies or the ugly freebies or the desired freebies. So these are discouraged in general. Then let's discuss for right now the positives only. So it addressed the immediate need of the poor. Then it uplifts the marginalized section. Then it also promotes the social security. So these are all the positives of the freebie. Now, what are the negatives of this freebie? So the race to freebie can lead to very quick fiscal disasters. This was said by the 15th Finance Commission member N.K. Singh, that race to provide freebies for winning elections and other purposes can lead to a fiscal disaster. इसका बहुत अच्छा एक एग्जाम्पल है पंजाब. तो पंजाब में ना जो डेट टू जीडीपी रेशियो है, डेट टू जीडीपी रेशियो वो इंक्रीज हो गया है 3% से ड्यू टू पोस्ट इलेक्शन फ्रीबीज. Then the negative is it distorts expenditure priority. The capital expenditure is less, the revenue expenditure is more. Then it also affect the credit culture. क्रेडिट कल्चर कैसे इफेक्ट करता है कि फार्मर्स को आप फ्री में ही दे रहे हो तो उनको ज़्यादा फ़र्क ही नहीं पड़ रहा है कि अभी लोन का रिपेमेंट करना है कि नहीं करना है. जस्ट गिव मी अ सेकंड. ओके तो फ्रीबीज़ के नेगेटिव इम्पैक्ट देख रहे थे. इन्वायरमेंटल इम्पैक्ट होता है, फ्री में पानी मिलता है तो बहुत वेस्टेज होता है, जैसे कि ग्रीन रेवोल्यूशन के टाइम पे भी देखा था. अब फ्यूचर जनरेशन पे बर्डन आता है इन चीज़ों का, तो उसकी वजह से इंटर जनरेशनल इक्विटी जो है अपनी हैम्पर होती है, और फिर एक्सेसिव डिपेंडेंसी हो जाती है यूनियन पे. सो इट ऑल्सो इज़ अ बर्डन ऑन द स्टेट एक्सचेकर ऑल्सो. So the taxpayers' income is used not for the benefits of public in general, but used as a tool for winning elections. तो इसका वे फॉरवर्ड क्या है? वे फॉरवर्ड इज फ्रीबीज में एक सनसेट क्लॉज होना चाहिए. सनसेट क्लॉज फॉर फ्रीबीज. देयर शुड बी रेगुलेशंस कि देयर शुड बी लिमिटेशंस, and there should be provisions for conduct and giving of freebies. Freebies मोस्टली इलेक्शंस में ही यूज़ किए जाते हैं, इलेक्शंस जीतने के लिए. और इलेक्शन से रिलेटेड हमारे यहाँ पे एक इशू इंडिया में और है, जो कि है अपना मॉडल कोड ऑफ कंडक्ट, MCC, मॉडल कोड ऑफ कंडक्ट. अब इसमें क्या इश्यूज़ हैं, व्हाट आर द मेजर्स रिक्वायर्ड, वो सब के साथ हम डील करेंगे. तो फर्स्ट ऑफ ऑल लेट अस सी सम पॉइंट्स सेट बाय आवर former chief election commissioners. So SY Qureshi, so he said that model code of conduct is a unique innovation that guides the conduct of political parties and candidates during election. So it is basically ensuring the free and fair election by curbing malpractices. And so this is a famous quote which you can use. You can maybe write it in your own words, but the essence must remain the same. So it was said by SY Qureshi, former Chief Election Commissioner of India. But what is MCC? So Model Code of Conduct, they are basically norms which ensures free and fair election. They provide a level playing field, and they provide that there is no malpractice during the election process. If we look into the history, for the first time in 1961 in Kerala, the MCC was implemented. One of the major issue with this is it does not have statutory backing. It is non-statutory. So this is one of the issues with respect to Model Code of Conduct. Now let us see what has been the recent Election Commission of India report. So it says that 99% action, there was 99% action on any MCC violation. So for any violation, almost we can say that actions were taken by Election Commission of India. What was the amount of seizure? Around 7,000 crore, or you can say 100 crores per day were seized by the Election Commission of India, which were illegal and were being used in the Lok Sabha elections. Then the ECI also transferred officials to provide free and fair election. बट अब ECI में ना, क्योंकि नॉन स्टैट्यूटरी है, तो इसके ना इम्प्लीमेंटेशन में दिक्कत होती है. अब व्हाट आर द इश्यूज, लेट अस सी इम्प्लीमेंटेशन में क्या दिक्कत है. नो प्रोएक्टिव एक्शंस आर टेकन. देयर इज नो लीगल एनफोर्सेबिलिटी ऑफ दिस थिंग. द स्कोप फॉर एक्शन is very limited, and there is negligible corrective measures available, and almost you can say the actions are again post-mortem in nature. So we can say this MCC is not as effective as it should have been. Now there have been some recommendations to make it more effective. For example, recommendations of the Law Commission. What did the Law Commission said? It said provide it legal backing. What will happen with legal backing? It will give independence to ECI, promote free and fair election. It will empower ECI to take pro moto actions, proactive actions, and it will create deterrence. So deterrence is the most important thing, which we have also discussed in the criminal justice system. So deterrence is must. So these were the recommendation of law commission. What are the measures required? The measures required to implement and do all this thing is build a political consensus over MCC, then strengthen the role of ECI through amendments and acts, then bring more transparency and accountability, and there is a need for increase in public awareness. So, for any conclusion, writing for writing any conclusion of this topic, you can say that apart from MCC, that is code of conduct, we also need moral code of conduct also. So ECI should make use of technology for surveillance and quick actions. This can also be written in way forward. So now, as we have seen that ECI has been a powerless body with a weapon of MCC, which is toothless in itself. So now let us also discuss Election Commission of India also. So Election Commission of India. Why it's not working? Election Commission of India provided in Article 324 of the Constitution. Again, for any answers with respect to this, you can mention Sayyid Qureshi's quote that ECI is lifeline of democracy and its independence is non-negotiable, and its independence is non-negotiable. So you can always quote the former chief election commissioners while writing down answers or essays with respect to these topics. Then the credibility of the electoral process also depends significantly on the independence of Election Commission of India only. Now, what has been the role of the ECI? It conducts election, then it regulates political party, it implements model code of conduct, then it is the body which resolves the dispute. So it is a disputes resolution is also a function of it regarding to party name, party symbol. महाराष्ट्र का एग्जाम्पल देखा ही होगा शिवसेना वाला केस. Then it also advises president for disqualification of members also. So this has been the role of the Election Commission of India. Now, what has been the issue? Issue is in first the most major issue is with respect to the appointment process. Appointment process. What is the issue? पहले इनको अपॉइंट करने के लिए एक 3-member बॉडी होती थी जिसमें there was PM, there was leader of opposition, there was CGI. Now what happened is Chief Election Commissioner and Other Commissioners Act 2023 को पास किया and this CGI was removed from this process. Now this committee consists of PM, leader of opposition, and a union minister appointed by a PM. So now technically you have barred the judicial member from the appointment process of such an important constitutional body, and you have technically you have kind of disabled the leader of opposition, because here decisions are taken on the majority. What the PM will say, the union minister nominated by him will say the same thing. So there is nothing left much for the leader of opposition also. So basically currently the appointment, you can say the appointment process is with the PM only. Not directly on paper, but you can say that whoever he will want will become the chief election commissioner, because here the decisions are to be taken by the majority, and this is the same unit, and he, the leader of opposition, stands no chance. Then another issue, let us see another issue also. What are the another issues? The ECI lacks permanent staff. Then they are not debarred from post retirement benefits. They are not debarred from further appointment also. Then there is no precise qualification provided. They lack funding autonomy. So for the fundings, they have to be dependent on the government only. Then there has been a politicization of the various posts of Election Commission of India. So what are the measures now required to improve all these things? What is the measure required? Let us discuss the measures required. So we need to strengthen the Election Commission of India. The Election Commission of India has the power to register political parties, but it does not have power to deregister political parties. So we need to strengthen the Election Commission, and for example, we can give them the power to deregister political parties. Then they should be debarred from further appointments, and also this will help in curbing the post retirement benefits. So for post retirement benefit, the better thing is there should be a cooling off period. Then financial expenses of the ECI should be charged upon consolidated fund of India. Then the ECI should move towards substantive democracy. This will increase the trust of the public in the democracy. So these are basically the reforms which can be done with respect to the Election Commission of India. बट ये तो हो गई इलेक्शन कमीशन ऑफ इंडिया की बात. अपार्ट फ्रॉम दिस द मॉडल कोड ऑफ कंडक्ट हमने देखा, इलेक्शन कमीशन ऑफ इंडिया हमने देखा, ये सब इन जनरल इलेक्टोरल रिफॉर्म्स हैं. तो एक सेपरेट टॉपिक इलेक्टोरल रिफॉर्म्स को भी पढ़ लेते हैं, देख लेते हैं इसमें और क्या क्या चीज़ें हैं. जस्ट गिव मी अ सेकेंड. इलेक्टोरल रिफॉर्म्स. सो सबसे पहले तो क्वेश्चन इज व्हाई वी नीड इलेक्टोरल रिफॉर्म्स. Why do we need electoral reforms? The answer is plain and simple. First is there is a criminalization of politics. Our Upanishad mentions that as is the seed, so is the fruit. जैसा बीज बोगे वैसा फल पाओगे. क्रिमिनलाइजेशन ऑफ पॉलिटिक्स है. 45% ऑफ MP they are charged under serious criminal charges. So if they will be making the law, then what expectations do you have from those laws made by the criminals only? This is one. Another issue is why we need electoral reform is we need legislative member who are persons or people with principles, as Gandhiji also said the same thing. And in India there is rule by the people and for the people, and to ensure this core of democracy, the core principle of democracy, we need free and fair election. That is one of the reasons why we need electoral reform. Then fourth is to reduce corruption, then to increase governance quality, then to build in social harmony. Then voters empowerment is also needed, and the voter turnout ratio needs to increase, the percentage needs to increase. Then we need fiscal prudence. So in the 18th Lok Sabha election, around 1.3 lakh crores were spent. This is the combined expenditure pan India, 1.3 lakh crore. So we need fiscal prudence. That is why we need reforms. Acha, why we need electoral reforms? We have studied, we have understood. What are the issues? एक बार वो भी देख लेते हैं. Issues क्या है? इंट्रा पार्टी डेमोक्रेसी नहीं है, वही पुराना इशू. ओपेक और बायस्ड पॉलिटिकल फंडिंग है. क्रिमिनलाइजेशन ऑफ पॉलिटिक्स है, गवर्नमेंट मशीनरी का मिसयूज़ है, देन एमसीसी टूथलेस है, देन एआई रिलेटेड इशू है, देर इज़ social media propaganda spreading phenomena. There is also use of deep fakes to uh, get political benefits. Then what has the ECI, Election Commission of India, and the Supreme Court, has they have they taken any steps to bring some reforms? So yes, let us see ECI's reform. It bought voter ID card. At the time of TN session, it was initiated to ensure that there is a photo on the voter ID and the fake votes can be uh, ended. Then EVM and VVPAT is also a good measure. Then we have the C Vigil app. This was the app I was talking about way back. So here you can report any MCC violation. Then when MCC was enforced, we have seen that around 7,000, 8,000 crore worth assets were seized during the 18th Lok Sabha election. Then we have KYC, Know Your Candidate app. Then we have postal ballot facilities also. So these are some of the electoral reforms taken by the ECI. Now, what has the Supreme Court done? So in the ADR versus Union of India case, the Supreme Court said that the political parties must disclose and also upload on a website the educational, the financial, and the criminal background of the candidate. So this is one thing. Then in Lily Thomas case, section 8 sub clause 4 of RPA was struck down. Then in PUCL versus Union of India, there was a provision for nota which was introduced via this case. Then Supreme Court also declared illegal the electoral bond scheme. है ना? But these all steps are not enough. There are some more recommendations which can be followed. What are the recommendations? And all these recommendations are by second ARC. So you can write second ARC's recommendation. Legally binding model code of conduct should be there. The rule making body under Representation of People Act 1951 should be Election Commission of India. Then there should be a permanent ban, permanent disqualification on members with criminal cases charged and going against them, and those who are especially the convicted ones, they should be permanently banned. The accused one should not be banned until they are convicted, but the convicted must be banned forever from contesting elections or any other way participating in the parliamentary function, because Rajya Sabha is a backdoor open for such candidates always. Then the power under anti-defection law needs to be given to the president and governor. एंटी डिफेक्शन लॉ, इसका पावर गवर्नर को और प्रेसिडेंट को देना चाहिए स्पीकर के बजाय, क्योंकि वहाँ पे फिर चांसेस रहते हैं पोलिटिसाइजेशन ऑफ द पोस्ट ऑफ स्पीकर. ये एक इशू हमने पहले ही पढ़ा है. पॉलिटिकल पार्टीज़ को आरटीआई के एम्बिट के अंदर लाना होगा. दिस इज ऑल्सो बीन सेट बाय सेकेंड ARC. अपार्ट फ्रॉम दिस, a state of funding of election, this was a recommendation given by the Indrajit Gupta committee. This can also be written in this can also be mentioned while writing any answer with respect to electoral reform. अब इसमें देख लेते हैं कि गवर्नमेंट ने क्या स्टेप्स लिए हैं. व्हाट आर द स्टेप्स टेकन बाय गवर्नमेंट. सो अभी जो नारी शक्ति अधिनियम आया था 2023 का, उसमें गवर्नमेंट ने रिजर्वेशन दिया है विमेन को, 1/3 रिजर्वेशन. नेक्स्ट इलेक्शन से वो अप्लाई होगा. देन देर हैव बीन कॉल्स फॉर वन नेशन वन इलेक्शन. Then also delimitation is conducted. So these are some of the measures, the steps which the government has taken. But iske baad bhi now, what are the barriers with respect to electoral reform? First is lack of political will ही नहीं है. Second, RC recommended that ban on criminal candidates. अब उसको इग्नोर कर दिया क्योंकि वही लोग लॉ मेकिंग में बैठे हुए हैं, वो क्यों बैन करेंगे. देन कॉन्स्टिट्यूशनल एंड पॉलिटिकल हर्डल्स हैं, बहुत सारे अमेंडमेंट लगेंगे आरपीए एक्ट में ये रिफॉर्म्स लाने के लिए, इसलिए भी काफ़ी कॉम्प्लेक्स प्रोसेस है. देन क्रिमिनलाइजेशन ऑफ पॉलिटिक्स, वो तो है ही है. एमसीसी, it is not legally binding, so bringing in such reforms without making it legally binding or statutory is nearly impossible. The ECI is toothless, which is also a barrier. It does not have power to deregister a party, it does not have power to disqualify, and there is also a weak electoral literacy in India. So this has also acted as a barrier in bringing in the electoral reforms. Now when we were discussing all these things, one major issue was with respect to political funding. Let us dive a bit in depth in this topic to understand political funding की क्या issues हैं. अब एक ADR का रिपोर्ट था. ADR का रिपोर्ट कहता है कि इन लोकसभा 18 जो हुआ था अभी, उसके इलेक्शन में बीजेपी ने अकेले 1500 करोड़ स्पेंड कर दिए. तो एक पार्टी इतना ज़्यादा पॉलिटिकली इलेक्शंस में ऐसा फंडिंग में इन्वेस्ट कर रहा है, तो दिस इज़ ऑब्वियसली अ कंसर्न फॉर आवर डेमोक्रेसी. देन let us comprehensively see what are the issues with respect to political funding. What are the issues? Let's discuss one by one. So the very first, in the last 20 years, national parties, they collected around somewhere more than 10,000 crore of funds from unknown resources. This has been mentioned in the ADR report. It's in the ADR report. So national parties are bringing in 10,000 crore rupees in the election spendings, and that too from unknown resources. We don't know what is the resource. This is one of the issues. Then what is the second issue? Second issue is concentration of funding. How? So ADR का report जो है वो ये कहता है that 88% of the fundings went to the ruling party only. So only 12% is distributed among the rest. बाकी 88% जितना भी डोनेशंस और फंडिंग आ रहा है, सारा रूलिंग पार्टी के लिए आ रहा है. दिस इज ऑल्सो अ इशू. देन 70% ऑफ फंडिंग इज स्पेंट ऑन स्टार कैंपेनर्स एंड पब्लिसिटी. दिस इज ऑल्सो बीन सेड इन the ADR report. Then other issues are that there is a disproportionate fund split. तो स्टेट पार्टीज़ को बहुत कम फंडिंग मिलता है, नेशनल पार्टीज़ को बहुत ज़्यादा मिलता है. और फिर एमपी का अगर केस स्टडी लेंगे तो एमपी में अराउंड 45% MLAs हैव एसेट्स ऑफ डिक्लेयर्ड एसेट्स ऑफ मोर देन 5 करोड़. सो इससे दिस इज़ क्लियर दैट देयर इज़ इशू विद रिस्पेक्ट टू पॉलिटिकल फंडिंग. अब जो ADR जिसने ये सारा रिपोर्ट बताया, इट हैज़ ऑल्सो सजेस्टेड सम रिफॉर्म्स. सो ADR suggestions, again the stylus is not working. ADR suggestions. What are ADR suggestions? It suggested that all the political parties must come under the ambit of RTI. Then it said that there must be a full disclosure, full disclosure of the donor who is donating. Then only, it said only online payment mode should be allowed for donating to in the contributing in the electoral funding. Then there should be a proactive public disclosure, and also there should be a annual audit approved by a, CAG approved auditor. So there must be a CAG approved auditor who should annually audit all the records of the finances which are coming. So what this will do, this will bring transparency also, and it will obviously curb corruption. So more or less in everything we are seeing that transparency in the functioning of government has always been an issue. Chalo, तो let us discuss something around transparency only. Now, what is this transparency? So basically, transparency is the availability of information in public domain as allowed by law. तो अब्राहम लिंकन का एक बहुत फेमस कोट था कि लेट द पीपल नो द फैक्ट एंड द कंट्री विल बी सेफ, है ना. सो होता क्या है ट्रांसपेरेंसी से? एफिशिएंसी आती है, देन फीडबैक आता है, देन अकाउंटेबिलिटी आती है, देन करप्शन कम होता है, देन देर इज़ ऑल्सो अ चेक एंड बैलेंस, फिर सिटीजन सेंट्रिक गवर्नेंस पॉसिबल हो पाती है. अब इसका एग्जांपल दूँ एक. फॉर एग्जांपल तेलंगाना में ना, तेलंगाना हैज़ इंटीग्रेटेड AI. सो इट हैज़ तेलंगाना आई पास for the industrial systems to enhance transparency. So this is example of transparency in the governance system. और transparency का इंडिया में जो बैकबोन है, it is the right to information act of 2005. तो चलो अब इसको भी डिस्कस कर लेते हैं, RTI एक्ट. So, right to information basically empowers the citizen to obtain information from public authorities, and it acts as a tool of participatory democracy. And it has various sections which defines what can be disclosed and what are the exceptions. For example, Section 2 of the RTI, it defines public authority. Then there is Section 4. It calls for proactive disclosure. Then there is also Section 8, which is the exceptions to the act. Some exceptions are also provided where the information cannot be disclosed. But now, what are the issues? What are the issues with respect to the RTI Act? The first issue is that Central Information Commissions and commissioner are becoming defunct. It is not said by me, it is said by Supreme Court that the Central Information Commission has become defunct. There are around 8 vacancies in CIC vacancies. So there are 8 vacancies in CIC, and the appeals pending with them is more than 20k, and only retired bureaucrats are appointed. It is a convention, though it's not a rule or it's not a law, but as per convention only retired bureaucrats are appointed. So tell me whether a retired bureaucrat will provide transparency in disposing the information if it's something related to his own work when he was in service. No, he won't. Then the government is not following the Supreme Court directives. So Supreme Court said that member from all walk of life should be appointed, but only retired bureaucrats are appointed. The government does not follow the Supreme Court guidelines. Then central government took power of deciding tenure, salary and conditions of services. thus it is a independence issue also. Then cases pending with the State Information Commission. तो कर्नाटक में इट इज़ 50,000 केसेस पेंडिंग, महाराष्ट्र में इट इज़ 100,000 केसेस पेंडिंग. Then there are also legislative loopholes. So the section 8 is used for denying the information. Then the Digital Personal Data Protection Act, denial of information under this act is also there. Then the RTI activists are in danger. So as per a report, in last 20 years there were around 95 deaths of the RTI activist. Then apart from these issues, there have been certain recommendations by the second ARC कि इनको कैसे ठीक किया जा सकता है. तो द सेकेंड ARC रिकमेंडेड दैट देयर शुड बी proactive disclosure. Then there should be suo moto updates by the information commission on the website. Then there should be scientific and digitalization of records and its management. Then there should be strengthening of the Central Information Commission and State Information Commission. Then there should be mass literacy and awareness campaigns. Then there should be narrowing down of the exemption clause, that is the section 8 of the this Right to Information Act. Apart from this, Supreme Court has also given various directions to the government that there should be time bound and transparent appointment. There should be complete appointment within 8 weeks, and a compliance report must be sent to the Supreme Court itself. Then we also need to, the Supreme Court said that not only in letter but also in the spirit the RTI needs to be implemented. So these are various guidelines which are being given by Supreme Court in various cases. अच्छा, बीच में एक टॉपिक हमारा रह गया था, दैट वाज विद रिस्पेक्ट टू पार्लियामेंट ओनली. द टॉपिक विद रिस्पेक्ट टू कोलिशन गवर्नमेंट. बहुत शॉर्ट में है, फटाफट क्विक पॉइंटर्स में बता देता हूँ. सो कोलिशन गवर्नमेंट में क्या होता है? सेवरल पॉलिटिकल पार्टीज विल जॉइन हैंड्स टू फॉर्म अ गवर्नमेंट विद अग्रीड एजेंडा. अब कोलिशन किस टाइप का हो सकता है? प्री पुल भी हो सकता है, पोस्ट पुल भी हो सकता है. अब इसमें दिक्कत क्या है? एक तो इसमें सबसे ज़्यादा जो इसके डिमेरिट्स हैं, एक तो गवर्नमेंट की इंस्टेबिलिटी रहती है. नेगेटिव्स लिख लेता हूँ. देयर इज़ अनस्टेबल गवर्नमेंट. तो इसका एक डेटा है कि 1990s में हम 1990s ऑनवर्ड्स 1989 से 2014 we have seen 10 times the PM have changed. So on an average in 25 years it should be 5 times only, क्योंकि 5 years पे election होता है, but 10 times PM have been changed. So there is a instability. Then the promotion of regionalism is there. Then the elephant-sized cabinet. Then horse trading and cases of deflection. Then the activism of judiciary and also the president and governor through the ordinance power, it also increases. Then there is policy paralysis. Then the leadership is curtailed. फॉर एग्जाम्पल टीस्टा वाटर एग्रीमेंट नहीं हो पाया था बिकॉज वेस्ट बंगाल अग्री नहीं हो पा रहा था उस चीज़ के लिए. देन देर इज़ अ फ्रीक्वेंट कोलैप्स एंड फ्रीक्वेंट नो कॉन्फिडेंस मोशंस आर पास्ड. गवर्नमेंट्स बार बार बनती हैं, पावर में आती हैं, एंड देन दे आर थ्रोन आउट ऑफ द पावर. बट इसके कुछ बेनिफिट्स भी हैं. व्हाट आर द बेनिफिट्स? पॉजिटिव्स देख लेते हैं. एक कंसेंशुअल डिसीजन मेकिंग पॉसिबल हो पाती है इसमें. बहुत डाइवर्स रेंज ऑफ पॉलिटिशियंस एंड पार्टीज इन्वॉल्व होती है, तो फेडरलिज्म भी प्रमोट हो जाता है. diverse range of interests are being promoted, diverse section get voice, then there is reduction of tyranny, क्योंकि concentration of power नहीं होता तो despotism नहीं होता, और फिर एक reduction of tyranny तो रहता ही है. बट जैसा कहते हैं ना, वेस्टर्न नेशंस में जो कोलेशन है इट इज़ बाय डिज़ाइन, बट इंडिया में जो है द कोलेशन इज़ बाय पॉलिटिकल कैलकुलेशन ओनली, जिसमें प्राइम मिनिस्टर मेयरली एक मैनेजर रह जाता है कोलेशन का. तो दिस इज़ वन ऑफ द merit demerit whatever you want to say of the coalition. Apart from it, but the coalition still keeps the checks on the powers, है ना, and there are multiple partners, so it is basically a so because of which what happens is the extreme ideologies are they basically take a back seat. They are not the priority of the government. दो वी हैव पॉजिटिव्स एंड नेगेटिव्स, बट एक फैक्ट बताता हूँ. 1952 से 1989 तक जो कांग्रेस सिस्टम रहा है हमारे देश में, द जीडीपी वाज अराउंड 4% ग्रोथ. 1989 टू 2014 का मैं बाद में बताता हूँ. पहले 2014 से 2024 द मोदी एरा, उसमें 5.1% रहा है. 1989 टू 2014 जहाँ 10 पीएम चेंज हुए, 10 अलग अलग गवर्नमेंट्स फॉर्म हुई, शॉकिंगली 5.8% हाईएस्ट जीडीपी उसी टाइम हम लोग का रहा है. तो दिस इज़ अ फैक्ट यू कैन यूज़ अगर पॉजिटिव लिखना हो कभी कोलिशन गवर्नमेंट का. बाकी कंक्लूजन में यू कैन राइट दैट पीएम शुड नॉट बी मेयरली अ मैनेजर ऑफ कोलिशन, एंड एंटी डिफेक्शंस और हॉर्स ट्रेडिंग के इश्यूज़ को रिजॉल्व करना चाहिए. एंड नॉन कॉन्फिडेंस का जो वोट लाया जाता है उसके पहले एक स्टेबिलिटी प्रोवाइड करने के लिए एक प्रपोजल या एक नए गवर्नमेंट के कॉन्फिडेंस मोशन भी आना चाहिए उसके साथ साथ ही. सो देयर शुड बी अ कंस्ट्रक्टिव नॉन कॉन्फिडेंस मोशन वोट, है ना. ओके, सो दिस इज डन. कोई ज़्यादा बड़ा टॉपिक था नहीं. देन द नेक्स्ट वन इज विद रिस्पेक्ट टू पार्लियामेंट्री प्रिविलेजेस. This I'll dictate, you just mention the notes very quickly in your copy or whatever, wherever you are writing. So parliamentary privileges, so basically these are special immunities or rights या exemption कह ले कि which are given to the legislature via article 105 to MPs and 195 to MLA and MLC. And this is also extended to the Attorney General of India. Then moving on to next, दो टाइप्स के होते हैं. कलेक्टिव पार्लियामेंट्री प्रिविलेज भी है और इंडिविजुअल भी है. कलेक्टिव में ये तो लक्ष्मीकांत में बेसिक मेंशन है कि सीक्रेट सिटिंग्स बुलवाई जा सकती हैं. देन द रिपोर्ट्स, डिबेट्स, प्रोसीडिंग्स वो जो है कैन बी डिनाइड टू बी पब्लिश्ड, है ना. प्रोहिबिट कर सकता है स्ट्रेंजर्स को उनके हियरिंग्स में आने से. मेंबर्स को ब्रीच ऑफ प्रिविलेज पे सस्पेंड कर सकते हैं. ये हो गया कलेक्टिव प्रिविलेजेस. अब इंडिविजुअल प्रिविलेजेस में वी हैव दैट द मेंबर कैन नॉट बी अरेस्टेड फॉर सिविल मैटर्स ओनली, नॉट फॉर क्रिमिनल, बट फॉर सिविल मैटर ही कैन नॉट बी अरेस्टेड ड्यूरिंग द सेशन, prior 40 days to the session and post 40 days after the session. Then the freedom of speech in house is also a privilege. Then there is an exemption from jury services during session. So the members of the parliament are exempted to give jury services during session. So these are basically the the privileges. So basically these features were borrowed from the British Constitution only. And the parliamentary privileges provides in a way independence and ensures the dignity and honor of the MPs also. And it also ensures that MPs it also secures MP from getting obstructed while discharging their legislative functions. अब इसके इश्यूज क्या हैं वो डिस्कस कर लेते हैं. तो इट इज़ अगेंस्ट आर्टिकल 14 विच टॉक्स अबाउट द रूल ऑफ लॉ. उसमें सबको इक्वल होना चाहिए, बट ये एक तरीके का एक्सेप्शन हो जाता है रूल ऑफ लॉ के लिए. फिर एक एलिटिस्ट मेंटालिटी को ये प्रमोट करता है. देन थर्ड इज जजेस ऑफ देयर ओन केस सिंड्रोम. सो जो ब्रीच हुआ है या कुछ भी है उस पे जो कमिटी ऑफ प्रिविलेजेस चीज़ें को देखती है, इट कंसिस्ट ऑफ द पार्लियामेंटेरियंस ओनली, सो दे आर ओनली द जजेस ऑफ देयर केसेस. तो कन्विक्शन इज नॉट that much, and hence the deterrence is also not significant. Then there is a threat to press and journalists. Then there is no clarity with respect to what constitutes parliamentary privileges, क्योंकि कोई codification नहीं है. Then it is also used as a political tool. So many of the MPs are regularly suspended on charges of breach of privilege, and mostly they are from opposition only. So we are not saying that this thing is not important. This is obviously important, but it needs to align with the constitution and fundamental rights, and also there should be codification of these parliamentary privileges, and lawmakers should use them with set standard principles and not for their personal benefit. So this is how you can conclude this topic. Now another topic with respect to the judiciary system was contempt of court. So very small topic, you can just listen and you will get through it. सारा याद हो जाएगा, जीवन भर रहेगा आपके साथ. तो contempt of court is mentioned in article 124 for Supreme Court and article 215 in High Court. So but वहाँ पे definition नहीं mention की है. Definition of contempt of court is mentioned in the Contempt of Court Act 1971. अब दो तरीके के contempt है. एक civil contempt है which includes the willful disobedience of the court's order. Then फिर एक criminal contempt है, like उसमें any word written या spoken या any act, any action that attempt to scandalize court's authority या anyone interfering in the judicial process or obstructing administration of justice, all this is categorized as criminal contempt. अब let us see कि why these powers were given actually. So first reason is to uphold the supremacy and integrity of the court. Then another reason is to ensure independence. Then third reason is to establish rule of law. Then ensuring public trust in judicial system. Then bringing in legitimacy in the judiciary, and last is creating an actual on-ground deterrence. So these were the reasons why these powers of contempt were given to the courts. Now what is the issue? The first issue is the definitions are very vague, and they have immense potential to curb the constructive criticism. They have potential of misuse also, and again this judges of their own case syndrome is also present here, like we have seen in the parliamentary privileges case. Then it also acts against the natural justice. Though Supreme Court has said in the S. Mugolkar case that the judiciary is not immune to constructive criticism, and to bring reform in this contempt of court, law commission mentioned that we need civil contempt, but there must be reforms in the criminal contempt, because there the things are a bit messy and vague. So we need reforms in criminal contempt. So this topic is done. Now let us discuss a very small topic but a very significant one of GS-2, that is good governance. So basically, first, what is governance? So governance is the process. It is the process of making decisions and the implementation of those decisions. So if this process is done towards ensuring the need of society, है ना, with sustainable use of resource, it is said to be as good governance. Now, the good governance is a subset. The governance is subset of good governance, and good governance is in itself a subset of ethical governance. So ethical governance is a wide term. It also Apart from good governance, it also has elements like apathy, integrity, honesty, probity, justice, accountability, fairness, compassion. So all these are also included in ethical governance. Then, what are the barriers with related to with respect to governance? That the laws are complex. There are archaic laws. Then there is attitudinal issue with respect to bureaucracy. Then there is layers in the decision making. Then there is limited citizen partnership. Sorry, there is a limited citizen participation, not partnership. Then there is corruption में तो corruption perception index में we rank 96 out of 180 in the 2024 वाला. Then there is lack of digitalization, there is lack of infrastructure. So these are basically the barriers with respect to good governance. अब now what are the steps taken? Legal reforms में देखें तो we had brought in RTI, and we also have Lokayukt, we have Lokpal. Then general reforms में देखें तो we have citizen charter, we have mechanism for social audit. Then schemes में देखें तो we have e-governance scheme, we have good governance scheme, we have direct benefit transfer, etc, etc. So all these are the reforms, the steps which we have taken. Then in conclusion, you can write that good governance and ethical governments ensure inclusive growth, and it also helps us achieve sustainable development goal number 16. So this can be a good conclusion to your answer. Now, as we have discussed the president and its ordinance power, in last year and even the last to last year, governor बहुत ज़्यादा news में रहा है, and his powers with respect to ordinance, so that has been in the lights of debates. तो इसको एक बार देख लेते हैं गवर्नर क्विकली. तो governor is basically Article 153 defines the role of governor. Article 155 appointment of the government by president. It is given in Article 155, and in Article 156 the tenure and the president's pleasure, that governor has a tenure on the pleasure of the president. It is mentioned in Article 156. Then the qualifications needed to become a governor, like he should be 35 years of age, he should not hold office of profit, he should be a citizen of India. All these are mentioned in Article 157 and 158 respectively. Remember one thing, grounds for removal of governor are not provided in the constitution. Now let us quickly look at the roles and functions of the governor. So basically he is the CEO of the state and a chief executive officer of the state he is. Then he appoints the CM, he appoints advocate general, he appoints the member of the state public service commission, he appoints the district judges. On the recommendation of president, he imposes the president rule, Article 356. Then he signs bill, then only it becomes act. He has ordinance power, he has power to pardon, remit, commute. But remember one thing, he cannot pardon death sentences or court martials, है ना. Then appointment of governor एक issue है छोटा सा, कि हमने कैनेडियन मॉडल अडॉप्ट किया है. सो देर आर टू मॉडल्स बेसिकली. अमेरिकन मॉडल वेयर द governor is directly elected, and then there is a Canadian model where the appointment is done by Governor General, that is the center in case of India. So why we chose the Canadian one? So B.R. Ambedkar, he said that governor office is a office of dignity. देखा ही होगा कि कितना आलीशान सब कुछ रहता है. So उसके अलावा he also said that governor under the constitution has no function he can discharge by himself. तो गवर्नर्स का जितना भी काम है, इट इज़ ओनली मतलब मेजॉरिटी ऑफ इट इज ऑन द रिकमेंडेशन ऑफ CM. So he works basically on the whatever the CM says. Mostly he has to do those things only. And at the time of separation 1947-1950, we had very separatist tendencies in states, है ना. सो वी चूज कैनेडियन मॉडल. उस टाइम पे गवर्नर को अमेरिकन मॉडल के हिसाब से पावर दे दी रहती तो द नेशन वुड हैव गॉट बाइफर्केटेड इनटू पीसेस. उसको क्या बोलते हैं, बाल्कनाइजेशन हो जाता. फिर अब इश्यूज क्या है विद रिस्पेक्ट टू गवर्नर रूल्स. तो फर्स्ट इज द मिसयूज ऑफ आर्टिकल 356 टू टॉपल द अपोजिशन. इसका प्रोमिनेंट एग्जांपल है इन 2016 सुप्रीम कोर्ट नलिफाइड द प्रेसिडेंट रूल विच वाज imposed on Arunachal Pradesh. Then issues with respect to pocket veto. The pocket veto is indefinite reservation. एग्जाम्पल में इसका लिख सकते हो कि नीट बिल था तमिलनाडु का. देन देयर इज अ पार्टीसनशिप एंड इन्वॉल्वेशन इन पॉलिटिकल टसल. तो टेक्निकली तो जो भी पर्सन गवर्नर बने वो पॉलिटिकली इनएक्टिव होना चाहिए, बट होता नहीं है. एंड देयर इज ऑलवेज अ पॉलिटिकल टसल वेयर द गवर्नर is appointed from the center, and the center has some other ruling party, and the state in which the governor is appointed that has other ruling party. तो वहाँ पे there is always a tussle. You can see prominent examples in Delhi, in Kerala. So this is the situation. Also in Punjab these days. Then another issue is partisan role of the governor at the time of hung assembly, because he is not a politically inactive person and he is associated with some party indirectly somehow. So at times of hung assembly he give favors to the political party whichever he belongs to. Then as a chancellor of state university, as you all know that all the state universities, the governor is the chancellor. So telling you an example of Maharashtra, so there was a tussle between the government and the governor over exam cancellation. So this is also an issue. Then governor's discretion is in a way center's discretion. So governor's discretion in itself is a issue, that the power to define what is the discretion of the governor lies in the discretion of the governor itself, and his discretion is center's discretion because he works on the pleasure of president, and the president, you very well know what happens there. तो गवर्नर्स डिस्क्रिशन इज सेंटर्स डिस्क्रिशन. तो ये दिक्कत है. तो इसमें बीपी सिंगल वर्सेस यूनियन ऑफ इंडिया 2010 का एक केस था जिसमें सुप्रीम कोर्ट ने बोला था कि प्रेसिडेंट कैन रिमूव गवर्नर्स बट दैट शुड नॉट बी आर्बिट्री, है ना. आर्बिट्री रिमूवल नहीं होनी चाहिए. देन गवर्नर समटाइम क्रिएट्स डेलिब्रेटिव लेजिस्लेटिव ऑब्स्ट्रक्शंस, जैसे कि केरला में बहुत सारे बिल डिक्लाइन किए थे 2023 और 2024 में. तो दैट हैज़ बीन अ इशू. देन अनदर इशू तो यही बता दिया था कि गवर्नर का डिस्क्रिशनरी पावर क्या है, वो डिफाइन करना ही गवर्नर का डिस्क्रिशन है. कुछ इम्पॉर्टेंट केसेस सुप्रीम कोर्ट्स के और कुछ कमिटीज़ की गाइडलाइंस हैं. दिस यू मस्ट नो, यू कैन यूज देम इन वेरियस मल्टीपल आंसर्स एंड essays also if needed. So first is SR बोमाई केस. उसमें सुप्रीम कोर्ट का गाइडलाइन था कि नो आर्बिट्री एप्लीकेशन ऑफ आर्टिकल 356 शुड बी देयर, एंड इट ऑल्सो गाइडेड द गवर्नमेंट टू प्लेस लिमिट्स ऑन गवर्नर्स पावर. Then the Supreme Court issued a directive that the floor assembly is the only place for the floor test, है ना. Then in Dr. J.P. Kulshestra versus Chancellor case, the Supreme Court said that the Chancellor of University must act on statutory provision. Then there were two commissions, Sarkaria Commission and Punchi Commission. So almost similar kind of recommendations they gave, like government should be an outsider, there should be consultation with CM while appointment of governor. Then the person who is being appointed as governor should be politically inactive for last few years. Then he should not be a member of the ruling party, and a guaranteed tenure should be given to him. अब पुंची कमीशन ने इसमें कुछ और अलग से नहीं बताया, बट वही वर्ड्स को अलग तरीके से कि सीएम कंसल्टेशन होना चाहिए, डॉक्ट्राइन ऑफ प्लेजर को डिलीट कर देना चाहिए, इनएक्टिव पॉलिटिशियन होना चाहिए, टर्म 5 ईयर का फिक्स टर्म होना चाहिए, और रिमूवल के लिए एक प्रोसेस उन्होंने बताई है, इम्पीचमेंट प्रोसेस होना चाहिए, दैट ओनली बाय स्टेट लेजिस्लेचर रेजोल्यूशन द गवर्नर शुड बी रिमूव एंड नॉट ऑन द प्रेसिडेंट्स प्लेजर. सो यही सारी रिकमेंडेशंस थी. अब एक और गवर्नर के पावर के साथ एक और इशू जो अभी करंट अफेयर में है, दैट इज़ गवर्नर्स पावर विद रिस्पेक्ट टू स्टेट बिल. अभी स्टेट बिल आर्टिकल 200 में गवर्नर के पावर बताता है कि या तो ही कैन गिव एसेंट, ही कैन विदहोल्ड एसेंट एंड सेंड बैक फॉर रिकमेंडेशन एक्सेप्ट इन मनी बिल केस, और ही कैन रिजर्व फॉर द प्रेसिडेंट. अब इसमें इशू ये है कि if he is reserving for president and if he is not giving assent and withholding the assent and he is keeping the bill with himself, there is no time limit of when he has to send it back for reconsideration or when he has to take the next step. And it is a discretionary power, and we have seen the discretionary power of the governor is the discretionary power of the center. So ये दिक्कत है. अब सोल्यूशन क्या है? सोल्यूशन यही है कि एक टाइम लिमिट होना चाहिए. देयर शुड बी अ टाइम लिमिट. सुप्रीम कोर्ट ने कई बार कहा है कि देयर शुड बी एज सून एज इट इज़ पॉसिबल ही नीड टू डिस्पोज द बिल्स. और सेकेंड ARC ने भी यही बोला था कि देयर नीड टू बी अ मैंडेटरी टाइम लिमिट प्रोविजन फॉर द ऑन द गवर्नर. देन NCRWC ने भी यही बोला है. अभी करंट अफेयर्स में ये था कि सुप्रीम कोर्ट ने एक जजमेंट दिया था, उसमें ये 3 पॉइंट बहुत इंपॉर्टेंट है. फर्स्ट तो ये है कि व्हेन अ बिल इज अगेन पास्ड, मतलब रीपास्ड, ऐसे गवर्नर के पास उन्होंने होल्ड करके रखा है और स्टेट लेजिस्लेटिव असेंबली उसको फिर से पास कर देती है. तो व्हेन अ बिल इज अगेन पास्ड आफ्टर रिकंसिडरेशन देन इट मस्ट बी पास्ड. देन 1 month टाइम फ्रेम फॉर विदहोल्डिंग एसेंट, उसका एक टाइम फ्रेम फिक्स कर दिया है. और फिर टाइम फ्रेम टू रिजर्व द बिल फॉर प्रेसिडेंट, उसको भी फिक्स कर दिया है 3 months. तो ये कुछ करंट अफेयर से रिलेटेड था सुप्रीम कोर्ट के जजमेंट. तो ये सारा डिस्कस करने के बाद कुछ और टॉपिक्स थे, जैसे कि फर्स्ट इज डिसेबिलिटी, देन डिसेबिलिटी के अलावा मेंटल हेल्थ, देन हेल्थ, देन एजिंग पॉपुलेशन एंड इट्स इशू, और फिर इंडियन हेल्थ केयर सिस्टम, ओबेसिटी, ओके. तो ये 1 2 3 4 5 टॉपिक्स हैं. फटाफट डिस्कस कर लेते हैं, 5 मिनट लगेगा. 1 मिनट में सारे टॉपिक्स ख़त्म कर देंगे डिस्कस करके. सो डिसेबिलिटी. अब मोदी जी का एक कोट है, उसको आप लिख सकते हो किसी भी आंसर में, दैट पर्सन विद डिसेबिलिटी आर केपेबल ऑफ ओवरकमिंग एनी चैलेंजेस, है ना, इफ़ प्रोवाइडेड एडुकेट सपोर्ट. So the greatest barrier to success for people with disability is not the disability itself, but the misconceptions and the lack of accessibility. Now, what is the issue with respect to person with disabilities? First is accessibility to infrastructure. More than 50% of our infrastructure is inaccessible. Then the public transport is also inaccessible. Then educational exclusion. Only 1% educational institute are disable friendly. Then there is the employment discrimination. We have around 1.3 crore disabled person who are employable, but only 34 lakh out of them are employed. Then there is a social stigma discrimination. Then there is access to healthcare and medical organization. Then 98% websites fail to comply with the person with disability friendly norms. Then there is also a misuse of the disability service, your disability certificate. You might have heard that Pooja Hetkar case. Then what are the measures में we have RPWD Act, है ना, Rights of Person with Disability Act 2016. So there are 21 disability recognized in this act. Then there is 4% reservation given in government job. There is also 5% reservation given in government educational institution. Then we also have Mental Health Care Act of 2017. Then we have National Trust Act of 1999. Then another government schemes like Accessible India campaign, Deen Dayal Disabled Rehabilitation Scheme, Unique Disability ID project, National Fellowship for Students with Disability, and Scholarship for PWDs. So there are various government schemes also, and we have signed the UN Convention on Rights of Persons with Disability. India is a signatory to that convention. Then we also have Divya Kala Shakti program also. Okay, so apart from this, you can always mention a case study of Brazil. In Brazil, now private sector also provides reservation for the person with disabilities. So this was a short topic. Now let us discuss mental health. So what is mental health? It is, so as per Gandhi ji, mental health is the health. It is the real wealth and not the pieces of gold and silver. But mental health is the real health. तो अभी कुछ डेटा बताता हूँ दैट ग्लोबली 2019 में आउट ऑफ 8% every 1% suffer from mental health issues. Then 2023 में एक स्टडी हुई थी दैट इंडिकेटेड 50% पीपल, है ना, विल डेवलप अ मेंटल हेल्थ डिसऑर्डर वर्ल्ड वाइड इन देयर लाइफ टाइम. NCERT का एक सर्वे था कि 50% ऑफ स्टूडेंट हैव एंजाइटी ड्यू टू the studies, and 30% have anxiety because of the exam results. So अब इंडिया में what is the reason for this rise? So the reason is rising urbanization, rise of nuclear family, poverty and financial distress is there. Then we have technological reasons also, like social media world. There is a lot of cyberbullying, there is a lot of fake lifestyle being promoted. Then academic reasons, NCERT ने बता ही दिया, 50% स्टडी की वजह से एनजाइटी है, 30% बिकॉज ऑफ एग्जाम रिजल्ट है. फैमिली रीज़न क्या है? हाई डिवोर्स केसेस होते रहते हैं, उसकी वजह से भी है. देन देर इज़ ऑल्सो लैक ऑफ अवेयरनेस. अब उसका इम्पैक्ट क्या होता है? इम्पैक्ट होता है उसका प्रोडक्टिविटी पे भी. हमारा इकोनॉमिक सर्वे कहता है बिकॉज ऑफ मेंटल हेल्थ द प्रोडक्टिविटी ऑफ अ पर्सन इज रिड्यूसिंग. WHO का ये कहना है कि अराउंड $1 ट्रिलियन का लॉस होगा in terms of productivity because of mental health issues. Rising unemployment है, increasing suicide rates हैं students में, increasing drug consumption है, decreasing academic performance है, and also there is involvement in the crime is also increasing. So these are basically all the impacts of mental health, poor mental health. Then what are the government initiatives? We have National Mental Health Program, we have National Tele-mental health program. So far around 8 lakh calls, via 8 lakh calls, the meditation has been provided, है ना. तो चिल्ड्रेन एंड यूथ सेंट्रिक प्रोग्राम्स भी हैं, लाइक आयुष्मान भारत स्कूल्स वी हैव हेल्थ एंड वेलनेस प्रोग्राम ऑल्सो. देन व्हाट इज द वे फॉरवर्ड? वे फॉरवर्ड इज वी नीड टू इंक्रीज मेंटल हेल्थ प्रोफेशनल्स, है ना. वी नीड टू डेवलप कॉम्प्रिहेंसिव गाइडलाइंस, एंड एट द फर्स्ट इंस्टेंस वी नीड टू एक्सेप्ट एंड रिकॉग्नाइज मेंटल हेल्थ एंड टर्म्स लाइक डिप्रेशंस, एंजाइटीज, डिसऑर्डर्स एज सीरियस इश्यूज. मतलब सोसाइटी में काफ़ी जगह पे आप देखोगे तो मजाक ही बना देते हैं कि डिप्रेशन जैसा कुछ नहीं होता. देखो, जिसको नहीं होता उसके लिए नहीं होता, बट जिसके लिए होता है उसके लिए तो हमें रिहैबिलिटेशन और उसके लिए तो हमें फैसिलिटेट करना पड़ेगा ना. तो वो चीज़ है. फिर कम्युनिटी बेस्ड सपोर्ट प्रमोट कर सकते हैं हम, NGOs के साथ पार्टनरशिप कर सकते हैं, और अर्ली एजुकेशन में जो है इंटरवेंशंस चाहिए इस चीज़ को सुधारने के लिए. तो वी आर डन विद मेंटल हेल्थ टॉपिक ऑल्सो. देन द नेक्स्ट इज एजिंग. अब परसेंटेज ऑफ जो ओल्डरली पॉपुलेशन है कंपेयर टू परसेंटेज ऑफ जनरल पॉपुलेशन, इट हैज़ ग्रोन फास्टर पर डेकेड. ये एक डेटा है हमारे पास. और बाय 2050 ना 20% ऑफ इंडियाज पॉपुलेशन विल बी इन ओल्ड एज, और 70% जो हमारी पॉपुलेशन है वो वैसे ही रूरल में रहती है, तो और जो है दिक्कतें बढ़ जाएंगी. सो दे आर इम्पॉर्टेंट, दीज ओल्ड पीपल, द एजिंग पॉपुलेशन, दे आर इम्पॉर्टेंट. वाई दे आर इम्पॉर्टेंट फॉर गिविंग वैल्यू एजुकेशन फॉर द यंगर जनरेशन, टू द यंगर generation. Then they have immense experience in multiple domains. Then they are also the drivers of silver economic. तो they drive the silver economy's growth. Silver economy में क्या है, जो नर्सिंग फैसिलिटीज़ वाले जो लोग हैं, जो काम करते हैं किसी के घर पे नर्सिंग प्रोवाइड करते हैं, उनके जो भी घर पे ओल्ड मेंबर्स हैं उन लोगों को, तो उस इकोनॉमी को बोलते हैं सिल्वर इकोनॉमी. तो उसकी ग्रोथ होगी. अब इश्यूज क्या है और उनके पीछे रीजंस क्या है, इस एजिंग से रिलेटेड क्या इशू है और क्या रीजन है. तो फाइनेंशियल डिपेंडेंसीज हैं. तो एनएसएसओ का रिपोर्ट कहता है 50% पेरेंट्स जो दे आर डिपेंडेंट ऑन चिल्ड्रन एंड 20% ऑफ देम आर बिलो पॉवर्टी लाइन. सो फाइनेंशियल डिपेंडेंसी इज वन इशू with regard to aging. Then second is mental health issue, depression है. 20% of the senior citizen population is suffering from mental health issue. Why? Because there is nuclear families. The parents are separated, their children are not living with them, they are being sent to some old age homes. So there are issues of loneliness, there are issues of depression. Then 75% of elderly suffers from chronic disease. This is also a issue, in when we know that around 50% of them are dependent on their children and 75% of them are suffering from chronic disease. So this is the issue. Then there is a rising crime against elderly. Then there is feminization of old age. So all these are the issues. Now why health is a concern? Because there is a low health insurance penetration in India. There is a lack of focus on geriatric care. Then the health services cost is high. The sedentary lifestyle leads to chronic disease, and the sedentary lifestyle is on the verge of increase. Then there is food insecurity also. What framework do we have? We have National Council for Senior Citizens. We have National Policy for Older people. We have National Social Assistance Scheme. We have Atal Bima Yojana. And in the Ayushman Bharat Yojana, we have this Jai component, where we are providing free health insurance to everybody above 70 years of age. Now, apart from all these, what else is required? What else is required? Number one, promoting healthy aging. Promoting healthy aging. The people in the aging and the 70 plus age groups must be healthy, free from chronic diseases, free from diabetes. Then there should be a holistic social security scheme. The budget spending should increase. The diseases should be addressed. There should be NGO integration. This is what else is needed. So we are done with this aging topic also. Now let us discuss obesity, and then finally we'll discuss the Indian health sector. And तो अभी let us discuss obesity. तो let me tell you some fact about India. India is facing a double burden. कैसे? अभी बताऊंगा. इंडिया में जो ग्लोबल हेल्थ इंडेक्स है, इंडिया उसमें 105th रैंक करता है ना. नेशनल फैमिली हेल्थ सर्वे कहता है 35% ऑफ आवर चिल्ड्रेन आर स्टंटेड, 19% आर वेस्टेड, 32% आर अंडर वेट. ठीक है. एंड ऑल्सो वी हैव माइक्रो न्यूट्रिएंट डेफिशिएंसी. वी हैव एनीमिया क्लोज टू 60% इन वुमेन at reproductive age. So there are issues of obesity, overweight, also issues of underweight and undernutrition, and also issues of malnutrition. That is why I was saying that India is facing a double burden. So let us discuss obesity. 450 million Indian will be obese by 2050. It is as per the claims of Lancet report. Around 45 crore people will be obese. 20 lakh crore would be the cost of non-communicable disease treatment. This is given by Niti Aayog. So as the income is increasing, the obesity is also increasing, because with the increasing income, the spending on the type of food consumed is not very healthy. More of the income is going on the pizza, the junk food, the fast food, and all those things. The Global Food Policy Report, it says that only 28% Indians have five necessary food groups on daily basis. So this is the issue. Now, what has been the causes? The cause is sedentary work culture, poor diet, fast food culture, ultra processed food culture, high chronic stress. Then there is sleep distress. Then there is weak consumer awareness. Then there is increasing income. Also, it is one of the after effects of globalization. Then we have lack of physical activities and the space. Then we have policy issue, failure in effective taxation and regulation of fast food. Then we have inflation in fruit and vegetable. So it is a very high cost of healthy living. So people do not opt for healthy food because it comes with a very high cost and it is unaffordable. Then India is then what is the impact? So impact has been, there has been a surge in non-communicable diseases, the non-communicable diseases is accounting for almost 65% of the deaths. Then India has become a global diabetic capital. Around 21 crore citizens of our nation are diabetic. Then insulin resistance in our youth is around 5%. Increases the expenses, out of pocket expenditure has increased. The productivity has declined. There has been an intergenerational transmission of obesity. Then the vulnerability has been critically increased for the for casualties, for increasing cases of drug abuse, for mental health detoxification, for frustration. So there has been a vulnerability that a person will be prone to some of these things. Then what has the government done? The government brought in the national program for non-communicable disease. It is running a Fit India movement. The FSSAI is promoting a Eat Right movement. Then we have Khelo India. Then we also have आज से थोड़ा कम initiative. आज से थोड़ा कम initiative में आज से थोड़ा कम मतलब the sugary and the fatty फूड कंजम्पशन उसको कम करने की बात करी है. देन कंपल्सरी लेबलिंग ऑफ पैकेज फूड is also a government initiative. Then रूको is repurpose used cooking oil. जो cooking oil को बार बार कढ़ाई में तल के स्ट्रीट वेंडर्स आपको देते रहते हैं, उसका यूज़ कर रहे हैं दूसरे पर्पस के लिए. तो repurpose यूज ऑफ कुकिंग ऑयल. देन और क्या कर सकते हैं? सऊदी अरेबिया का मॉडल है, दैट इज टैक्सिंग शुगरी ड्रिंक एंड अनहेल्दी फूड, वो अप्लाई कर सकते हैं. वहाँ पे सऊदी अरेबिया में ऑल द रेस्टोरेंट्स हैव कैलोरी लेबलिंग इन देयर मेन्यू, वो हम यहाँ इम्प्लीमेंट कर सकते हैं. और ट्रांस फैट को उन्होंने एलिमिनेट कर दिया है, वही चीज़ हमें भी करनी चाहिए. अपार्ट फ्रॉम इट वी कैन मूव from campaign towards regulation strictness. Then also urban planning must integrate jogging parks, gym parks, etc. So that there is a space for doing physical activities. Then we should focus on millets. It has immense benefit, protein benefits, nutritional benefit, soil management, agroclimatic conditions. Where there is a dry region, we can use millet. So it has immense potential in environment, in agriculture, in food, in health, everything. So we can conclude or we can introduce any answer of obesity by saying that obesity is a silent pandemic and now is the need for India to deal with it. Okay, so the topic of obesity is now also done. I think my laptop, my tab is not working properly. But okay, I'll finish the last topic, that is the Indian healthcare system. So, what is health first of all? So, WHO says that health is a state of complete physical and mental plus social well-being and not just merely absence of disease. And our economic survey of 2025, it also says that health is an important development pillar. So the economic survey mentions health as an important development pillar for robust and healthy economy. Then what are the pillars of India's health policy? So the pillars of India's health policy are preventive health care, early detection, low cost treatment, rural doctor availability, and integration of technology. Now the question is, what are the issues in Indian healthcare system, and what are the issues that, not issues, but what are the barriers which are between which are in front of India uh, and stopping India to achieve the universal health coverage. First is out of pocket expenditure on health. It is around 40%, which pushes public into poverty. And there is a very unfortunately there is a very famous saying that you are just one health accident away from poverty, and you will fall below poverty line. Then another thing is that the government health expenditure to percentage of GDP is less than 2. It is very very low. If you will see in the developed country, it is in double figures. We have less than 2. Then insurance coverage still does not cover around 400 million people in India. So that is also an issue. Then apart from it, the doctor to population ratio, the UN suggested is one doctor per 1,000 patient, but India's reality is one doctor per 815 patient. So this is way better than the UN standard. वो तो 1000 पे एक बोल रहा है, हमारे पास तो 815 पे एक है. लेकिन इसमें इशू क्या है कि ये अर्बन डोमिनेटेड है. तो 65% ऑफ पॉपुलेशन, सॉरी 65% ऑफ डॉक्टर्स जो हमारे हैं वो अर्बन एरियाज में है, और हमारी 75% पॉपुलेशन तो रूरल एरियाज में है. सो दिस डिस्क्रिपेंसी इज अनदर इशू. देन अवेलेबिलिटी ऑफ बेड पर पॉपुलेशन, ये रेशियो हमारा बहुत खराब है. WHO कहता है 3 बेड्स पर 1000 पर्सन होने चाहिए. हमारे पास ओनली हाफ, दैट इज 0.5 बेड पर 1000 पेशेंट्स है. Then 60% of our public health centers are at very poor state. There are unjust claim denial with respect to the health insurance. Then 70% of OPD is dominated by private sector. And you know that private sector is very inaccessible and affordability is out of majority's reach. Then there is no price regulation mechanism in private healthcare sector. That is also a big issue. So now, what are the government, what is required and what are the government measures? So first is increase expenditure in public infrastructure, especially tier 1 and tier 2 cities. Then price regulation on private hospital has to be done with some regulations, with some rules. Because they are charging blindly for anything. They are charging the same this thing, normal mask, the same mask you will get in 5 rupees from anywhere. But if you will go in a private hospital's medical and you will ask there, it will cost you 25 rupees, 50 rupees. So that is, they are charging like anything. Then there need to be adoption of technology, like we have already did a brilliant job in this by launching in the e-Sanjeevani app. Then focus must be on strengthening preventive healthcare mechanism also, है ना. So what are the things which we need to do? E-Sanjeevani app, through which we have telemeditation, we can have consultation online. I told you the national tele health program which the government started, almost it benefited around 8 lakh callers, है ना. Then Ayushman Bharat digital mission is there. We can use the AI in diagnosis, and here you can write the Rajasthan model of using artificial intelligence in diagnosis of disease. Then we have iDrone, that is meditation via drone in inaccessible topography, है ना. Then we also have e-Swasth Dham model of Uttarakhand. So basically, in Uttarakhand, for all the religious tourists, there is a e-Swasth Dham. So all this are steps which have been taken, and some of them are what we have to do more. After this, only a very few topics of GS-2 are remaining, and maybe we'll complete in this part only, or we'll make another separate video for completion of that. इसके बाद नेक्स्ट टॉपिक है डिसेंट्रलाइजेशन. कुछ टॉपिक और कर लेते हैं. Decentralization. So decentralization is basically the transfer of authority, resources, responsibility from a central authority to grassroots level authority. So it is central authority is transferring what? It is transferring authority, resources, responsibility to the grassroots levels. Now in India, the 73rd, 74th Constitutional Amendment Act are the constitutional measures. Then in legal measures we have PESA Act, then we have Forest Rights Act of 2006. Then for financial measures of decentralization we have Finance Commission, which plays a role in devolution of money to states. Now, what is the benefit of this decentralization? What is the benefit? So, it is in line with the Gandhian philosophy of Gram Swaraj. Then it leads to participatory democracy. Then, because of decentralization, the decision making is very quick, and it is also citizen centric administration. Then effective accountability is also ensured. Then there are lesser leakages and chances of corruption with respect to fund. And it is also empowering women. How it is empowering women? So out of 34 lakh, 3.4 million around something posts are there, which are reserved, out of which one third are reserved for women. So around 13 or 14 lakh posts are held by women, which were introduced through the 73rd Constitutional Amendment Act. Then a case study of good governance and its result is Nagar district of Maharashtra. So there is a liquor ban in several gram panchayats. Now there are some issues with respect to decentralization. Now what are the issues? So first issue is with respect to the framework. Now the electoral process and the delimitation process. So there is delay in the electoral process. So we have example of Maharashtra, where the election was supposed to be held every 5 years, but it took 8 years. It took 8 years of gap to elect the new this both municipal bodies and the Panchayati Raj. Even in MP, 2018 was the time when the election should have been held, or I think 2018 or 2020 it was time, but then it was held in 2022. So there were delays there also. Then there is this issue of delimitation issue. So the political parties, the ruling majorly the ruling party, it uses the delimitation for its benefit. So there is a politicization of the delimitation process. Then another issue is issue with respect to functioning. So only 20% states have devolved all the 29 subjects under the 11th schedule to the grassroots levels. Then there is emergence of parastatal bodies. There are various bodies which are performing same functions which are mentioned in the 11th schedule. Then there are issues with respect to finance. So the own tax revenue of Panchayati Raj institution is just 1%. They get 80% revenue from center and around 15 to 17% from states. So financing is one of the major issue. And out of this 80%, most of the funds are tied with central sector schemes of the center. So you cannot diverge these funds in some other activities. Then there is also constant interference by the MLAs and the elected MPs of that area. Then the State Election Commission, which is responsible for the election of these bodies is not independent, they are appointed by the state government. And another thing is, there is around 25% vacancies at post of secretaries in panchayat. So this was basically in a report given by the Bose committee, which has mentioned that there is 25% of vacancy. Then 40,000 gram panchayats do not have computers. They don't have computer. Then there is poor training and lack of skill also. Then there is weak community participation and the awareness level is very less. Then there are also issues of pati pradhan, this concept where the seats are reserved for women, but only on paper the women is contesting the elections, but in reality his husband or maybe his brother or maybe his father is the one who is actually ruling and actually doing the things. Now what are the measures? So we have seen the benefits, we have seen the issues. Let us now look at the measures. What are the measures? So measures is 15th Finance Commission has increased the revenue by around 1.5 times to Panchayati Raj institution. Then we also have Rashtriya Gram Swaraj Abhiyan. तो इसमें there is provision for training in governance. Then there is Panchayat Devolution Index also, which promotes competitive federalism. Then, with respect to this, we also have awards, various awards given to the best Panchayati Raj institution. Then we have e-Panchayat initiative to digitalize the process. Then, isme you can write the case study of Kerala. So they did activity mapping, and the activities were devolved to grassroots level. So this is a case study which you can write. Then there are some suggestions suggested by the second ARC report. So it said that there should be more untied funds devolved to the Panchayati Raj institution. Then the funds should be timely released because we have issues of delay in releasing of fund. Then the PRI should have power to recruit the staff and the personnels. Then they should also focus on eliminating the election delays which are caused. So there is a quote where you can write that it says that Viksit Bharat can be achieved through Viksit Panchayat. You can use this in the conclusions with respect to any answer with regard to devolution of power and the Panchayati Raj institution. Then another topic linked with this one is the PESA Act, Panchayati Raj Extension to Schedule Area 1996, I think. Just check this year once. So this was done to extend the PRI in the fifth schedule area with certain modifications. So basically PESA gave greater power of self-governance to the Gram Sabha. So now what were the powers of Gram Sabha? So the Gram Sabha now has power to approve plans, they had power to approve project, they had power to approve program, है ना. They also acted as a dispute resolution mechanism. They also regulated the intoxicants in various gram sabhas, like we have studied about the Ahilya Nagar, that there were ban in various gram sabha. The liquor was banned by the gram sabha. Then they got the powers to write over minor forest produce. Then they had powers with respect to mineral resources. They had powers with respect to managing of the local market. Then why was this PESA bought in? So basically this PESA was bought in because there was a feeling of tribal alienation which we had to reduce. So to reduce tribal alienation, to empower the tribal for inclusive growth, and also to curb the issues with regard to Naxalism, because Naxalism started because of this feeling of alienation. Then what are the issues with respect to this PESA Act? Now what are the issues? So Zaza, there was a Zaza committee, we also say it Kaga committee. So the though the recommendation of this committee were not implemented, they just remained on the paper, they were not implemented in the spirit. So what it said that there must be no delay in implementation. For example, there was delay in implementation in Odisha. Then many law passed, there are many law which are being passed to dilute this power given to the Gram Sabha, like the Land Acquisition Act. So it should not happen. Then the Gram Sabha are not aware about their right, so they need to be aware, they need to be get informed about their rights. Then we have incidents of violation of the PESA Act in various uh, gram sabhas. Then there is also a bureaucratic apathy. So these were the issues, but what were the outcomes of this PESA? So if you look at the outcomes, majorly they were positive. The forest cover got increased, and there was resistance to mining and deforestation. You can write Vedanta case study. Then there was democratic decentralization. Then there is also decline in the left wing extremism. So this is also a positive factor about. So the 74th Constitution Amendment Act talks about the urban local bodies. So basically it's mentioned in the 12th schedule, and it is part 9A of the Constitution. So there is a very famous quote then when power is closest to the people, participation is maximum. And इसका मतलब ये है कि power in democracy is of the people, and when it is closest to the people, the participation भी maximum होता है. Now talking about the urban local body, भैया इनका क्या रोल है? Provides services, infrastructure, urban planning, ease of doing business में help करते हैं, women empowerment, grassroots level decision making. Then it is a bottom up approach, then works on urban issues like waste management, disaster management, sorry. Then इनके सोर्सेस ऑफ रेवेन्यू क्या है? एक तो ओन टैक्स है, टैक्स और नॉन टैक्स हो गया. देन दे हैव ग्रांट्स फ्रॉम द यूनियन, आर्टिकल 280 finance commission recommends this. Then they get loan from states and financial institution. Then article 243, there is also devolution of funds from state as per the recommendation of states finance commission. Now what is the issue with respect to finances? So with respect to finances, the issue is that there is a very low overall revenue receipt, and share in GDP is less than 1%. Then own revenue is less than 50%, and inefficiency in tax collection is there. Then there is reduced local taxes under GST. Then there is poor recovery from services. Then there is large variation across India. So share in state GDP somewhere is more than 1% like Delhi, Chandigarh, and somewhere it is less than 0.10% also. For example, there is Assam, there is Sikkim. Then dependency on the intergovernmental transfer. Then 70% of their expenditure is revenue expenditure. Accounts are not maintained properly. This has been said in a CAG report. Now, what are the reforms required? So, reforms required are, or what can be done? So, tax devolution is one thing. Then, user charges must be uniform throughout India. Then, there should be cooperation from state government. Then, the CAG should audit the accounts of urban local bodies and PRIs. Then there can be bond issuance like the municipal bond. There can be devolution from GST for urban local bodies also. And then there is actually city financing ranking institution which will promote competitive ranking. इसमें ना any cases with regarding to urban local body you can write the case study of Indore. So Indore, cleanest city for 6 consecutive years. How? So it has 100% waste segregation at source only. Then it processes around 1900 tons of municipal waste per day. Then in Indore, the workers of municipalities are known as सफाई मित्रास. अब इसको यूज़ करो एज वर्क कल्चर के एग्जाम्पल में, है ना. एथिक्स में यूज़ कर सकते हो, जीएस में यूज़ कर सकते हो, GS-2 में यूज़ कर सकते हो, 3 में यूज़ कर सकते हो, जहाँ भी चाहो. सोसाइटी GS-1 में भी अगर लगे तो यूज़ करो. सो दिस इज़ अ केस स्टडी. इंदौर के बारे में थोड़ा बहुत आप लिख सकते हो. इंडिया का मैप बना के मार्क कर देना, MP में है. एंड फिर 15 फाइनेंस कमीशन ने क्या किया है विद रिस्पेक्ट टू अर्बन लोकल बॉडीज़ एंड पंचायती राज इंस्टीट्यूशन. सो उसने कुछ मैंडेटरी कंडीशंस रखी हैं टू अवेल ग्रांट. तो ग्रांट्स सिर्फ ये मैंडेटरी कंडीशंस फुलफिल करने पे ही मिलेंगी. क्या है कि फर्स्ट देयर शुड बी अ फॉर्मेशन ऑफ स्टेट फाइनेंस कमीशन. Then there should be posting of accounts audit on online platform, and then there should be floor rates, that is minimum property tax should be fixed. The floor rates must be fixed. now इंदौर वाले में हमने इंदौर में ना देयर वाज अ स्कीम विद रिस्पेक्ट टू म्यूनसिपल बॉन्ड्स. तो चलो एक बार पहले म्यूनसिपल बॉन्ड्स बता देता हूँ. व्हाट आर दीज. सो बेसिकली इट इज़ अ डेट इंस्ट्रूमेंट issued by municipal corporation with the purpose of raising funds that can be used for financing the socio-economic development project, है ना. These bonds, the bonds and the interest, they both are tax exempted. So this is municipal bond. Now what is the challenge with respect to municipal bond? There is a grant dependency. There is accounting inconsistencies. Then investors' confidence is low. Then the maturity period is very high. Therefore, it is low liquidity. And then the alternative available for municipal bonds are way better than this. But after all these, also we are seeing that they have still immense potential. How? Because you see, when Indore launched its green bond, they got almost 5.91 times more subscription. So it is really a good number. Then what are the challenges faced by urban local bodies, ये भी देख लेते हैं. Financial issues हमने डिस्कस किए काफ़ी सारे ऑलरेडी. फिर लिमिटेड डिवोल्यूशन ऑफ पावर है. एटीट्यूड ऑफ स्टेट गवर्नमेंट ठीक नहीं है. अब जैसे बिहार म्यूनसिपल अमेंडमेंट एक्ट 2021 लाए थे, इसमें जो C&D ग्रेड्स एम्प्लॉयज़ थे उनकी अपॉइंटमेंट की पावर जो है ULB से लेके स्टेट गवर्नमेंट ने अपने पास ले ली थी. तो इसको फिर सुप्रीम कोर्ट ने अनकॉन्स्टिट्यूशनल भी हाई कोर्ट ने अनकॉन्स्टिट्यूशनल भी डिक्लेयर किया. सो दिस इज़ ऑल्सो इशू. Then there is this politicization of urban local bodies. Then there is low per capita expenditure. In India, it is around $17. You see, whereas in China it is $116. Then there is also issue of unplanned urbanization or the urban sprawl. Now, what are the way forward? So, as per second ARC, it recommended that mayor election should be direct. In some places it is direct, but in many places it is not direct. So the mayor election should be direct. Then water should be a subject under municipality. Then public private participation options should be explored. Then the transport systems should be given to the municipalities and they need to work for the improvement of the system. अब इसमें केस स्टडी चंडीगढ़ की है. चंडीगढ़ में एक कॉन्सेप्ट है गार्डन सिटीज़ का. So what are these garden cities? Basically, these are neighborhood parks which are maintained by the Resident Welfare Association under some sort of supervision of urban local body. So what this does is this promote citizen centric governance, also participatory democracy, as the Resident Welfare Association is maintaining the neighborhood parks. And when the people, the citizens, are involved in such activities, there is a sense of belongingness, and then the things are way much more better than how some government institute would have done. So that's it. Oh, I think नीचे से हमने ऊपर लिख दिया. नो इश्यूज, दैट्स फाइन. अच्छा, ऑफिस ऑफ प्रॉफिट एक टॉपिक है, क्विकली पढ़ा देता हूँ. इसके नोट्स बना लेना खुद से. तो आर्टिकल 102 फॉर MPs, आर्टिकल 191 फॉर MLAs mention disqualification if a person holds office of profit. But remember, office of profit is not defined in the constitution. So basically सुप्रीम कोर्ट का 1969 का एक जजमेंट है with respect to the गुरु गोविंद case, where they have given certain guidelines. They have basically given 5 criterias. So anyone, if any of the criteria among these 5 is done by the government, then it will be considered as office of profit. क्या criteria है? Who is the appointment authority? Government है, then it is office of profit. Who has terminating power? अगर government है तो it is office of profit. Who decides the remuneration? अगर government है तो it is office of profit. What is the source of remuneration? अगर government है then it's office of profit. Then what powers come with the office? अगर कुछ government से related power है तो then it is office of profit. Now what are the issues? So basically it is first, so it is again so second issue is that it creates a conflict of interest. Then it also affects the accountability. Then it is in conflict with the 91st Constitutional Amendment Act. Now when we have seen this word conflict of interest, now what is conflict of interest and uske impact kya hai? So conflict of interest is basically when the primary interest or the public interest is affected by a secondary or private interest. So it can be public interest versus private interest, then it can be corporate interest versus personal interest, then it can also be corporate interest versus public interest, like polluting the rivers. So conflict of interest is not equals, no, it is not same as the ethical dilemma. So in ethical dilemma there is a conflict between two equal, both either right or wrong things. Example is economy versus environment, equity versus equality, RTI versus Secrecy Act. Now how to deal with this dilemma? First you should look for constitutional value. Then if there is some code of conduct and ethics, you can follow them. Then you can look at the Gandhian talisman and do accordingly. Now what is this difference between code of ethics and code of conduct? So basically code of ethics are generalized value, they are difficult to implement, their implementation is internal, and they are permanent in nature, and they have a wider scope. Whereas code of conduct is, the directions are very specific, the directions are easy to implement, the implementation is external. For example, there is all India services rule that has limit on receiving gifts. Then it is temporary in nature and the scope is also narrow. Like rule 11A of all India services, it does not allow to be the person to get involved into the dowry practice. So the next topic is the post of speaker. Article 93 mentions the post of speaker, and this post has origin in the 1919 Montague Chelmsford reform. What is the role of the speaker? He maintains the decorum of house. He decides on the matter whether a bill is moneyable or not. He decides on matter of 10th schedule. He has the power to uh, call for a secret meeting, and he also presides the joint sitting. He is the principal spokesperson of the parliament. Then he has adjournment power. Then he is the final interpreter of the rules of the house. Then he also have casting votes. Now what are the issues? Issues with respect to power of deciding money bill, है ना? This is basically, this power of deciding money bill is sometime used to bypass Raj Sabha. Then there is delay in decision with respect to anti-defection law. Then there is partition role. There is the politicization of the post of speaker. Then there is delay in the deputy speaker election. Then there is the neutral stance is basically compromised. Now what's needed? So complete political neutrality is needed. Aim should be protecting the voice of opposition. Then timely election of deputy speaker is also required. Now we have seen this anti-defection. Let us discuss it in detail. So basically 52nd Constitutional Amendment Act and the 10th schedule mentions the anti-defection law. What is the criteria? So voluntary giving up membership of the party, voting against the whip, and nominated member if she joins a party after 6 months, or if any independent candidate after winning the election joins a party, then all these four comes under the criteria of anti-defection. Only two exemptions are there. One is party merger, and second is if two-third members of the party defects. Then what are the issues? Issues is that the provisions are very vague. There is the wholesale defection is promoted. Then it curbs intra-party democracy. It puts a ban on freedom of speech, and this does not speak about pre-poll alliance. It leads to centralization also. Then the role of speaker has not been impartial in these the cases of deciding anti-defection of the member. Then there is no timeline for taking decisions for the speaker. He can delay if he wants. It is at his will. There is no particular timeline suggested for it. Then there is suppression of members of voices by the whip. Then there is post facto adjudication. That is, defection happens and then the government has fallen. Now, after that, you are defecting the MP or MLA, then the damage is already been done. The government has been destabilized. Then what are the suggestions for this thing? The suggestion is that speaker should decide within a time frame. Then the law commission said that the pre-pool alliance should be under anti-defection law. And then there is one more recommendation that the president and governor, they should decide. They should have the authority uh, to decide on the matters of anti-defection law with with consultation with chief elector. Then there is another topic with respect to parliament, that is the whip. Now, what is whip? Whip is basically, it can be a role. It is a role played by a person. So a person can be a whip, and also the directions given by the party can also be said as to be a whip. Now there are types of whip. There is one line whip, there is two line whip, and there is three line whip. So one line whip is basically, in this the members have the liberty whether to come or not. In two line whip, the attendance is mandatory, and in third line whip, specific directions are provided with respect to voting. Then what is the role of whip? So what is the role? So basically role is he provides discipline on floor, then he ensures attendance, Then he ensures that the voting is done with in line with the party ideology. Then it also acts as a advisor to new member. So this is the role. Now, what are the issues with respect to whip? First is it is against the individual consensus. Then it suppresses the freedom of speech, the freedom of action. Then there is centralization of power. Then it also diminishes participatory democracy. So basically, if you look at the UK's model, na, in UK, if a person is voting against the party guideline, then he is removed from the party, but he is not removed from the post of the member of the house. So the Supreme Court also said that the whip would be elected by leader of political parties. So basically, few years back there was a case, the Shiv Sena case in Maharashtra. So in that case, the Supreme Court said that the whip must be elected by the political parties and not by the high command of a particular party. Because what will happen then? Only the high command, whatever he'll say, everyone will have to follow. There will be no voice of individual members. So the Supreme Court also ruled out it in one of the decisions. Another important topic is tribunal. Now, what are tribunal? They are basically quasi-judicial body introduced by Article 323, 323B and 323A. They were introduced via 42nd Constitutional Amendment Act and they work on principle of natural justice. Now, these tribunals have some issues. Now, what are the issues? First issue is with respect to vacancy. There is around uh, 23 out of the 34 seats in the armed force tribunals are vacant. Then there is issue of non-uniformity. Then it is against the separation of power. Then it leads to conflict of interest. When the cases are not resolved here, it further increases the pendency. It is not accessible. Then it lacks autonomy because it is dependent on the ministry for the funds. Then it has led to the phenomena of tribalization of justice. So there is overcrowding of the tribunals. There are multiple tribunals and they have overlapping jurisdiction. And these have issues with respect to digitalization. They are not yet digitalized. Then the appointment process, it is opaque appointment process. Just give me a second. Sorry. So the appointment process is also opaque. So we have discussed the issues with respect to tribunals. अब एक evolution बता देता हूँ कि how tribunals evolved and then फिर I'll tell you the recommendations with respect to tribunals. So in 2017 there was a Finance Act. So it brought reforms in tribunals. So the service conditions and rules were defined by the government of India and there was no security of tenure. So in 2019, Supreme Court squashed this provision of the act. So what government did in 2020, the government again passed this bill, the Finance Act, with very insignificant changes. The provisions which led to the squashing of the bill by Supreme Court were not changed, and again it was passed in 2020. Then what happened? The Supreme Court again in 2020 cancelled this bill. Then in 2021, a tribunal reform ordinance was uh, promulgated. This said that okay, we'll include the CGI in search cum selection committee and we'll fix the term for 4 years. But Supreme Court in its earlier orders said कि 5 years होना चाहिए. Then it also talked about merger of tribunals, but this was also not fulfilling the conditions which were set by Supreme Court in the order which was given in 2019, where it squashed the Finance Act. So again, in 2021, the Supreme Court again squashed this thing, it cancelled out this thing in the Madras Bar Association versus Union of India case. So this is basically a background. कोई पूछेगा नहीं, but you must know. Then what are the recommendations? So basically recommendation is that there should be a national tribunal commission to ensure the independence of the tribunals. Then there should be a judicial majority in tribunals. Then in L L Chandrakumar case, the Supreme Court said that certain tribunals are replacing High Court. So, in cases where the tribunals are replacing High Courts, the tribunal must get equal judicial independence uh, as the High Courts have with themselves. And then the last suggestion is uh, adoption of technology and digitalization. So this is one of the recommendation. Now topic the next topic is NGO, non-governmental organization. So what are these? These are basically not-for-profit organization. They promote the interest of the poor persons. They also have a role in protection of environment. They provide social services. They undertake community development. So basically NGO has a purpose, should have a public purpose. Then it should be a non-state and non-political body. Then it should have a self-governing mechanism. It should be not for profit organization. And what it does is it bridges the gap between government and public. You can also write it as it bridges the gap between government and governance. So in India currently there are around 3.4 or 3.5 million, or mostly more than these registered NGO, more than 35 lakh registered NGO. Now what is the importance of NGOs? So they fill the gap between the government, where the government is unable to reach. They provide feedback mechanism. They focus on capacity building. They become the voice of the voiceless, and they act as a tool for participatory democracy or participatory governance. They provide input via research. For example, we have the ADR, जिसकी reports के बारे में हम बात करते रहते हैं. Then we also have Pratham NGO. So basically these are the roles which are played by NGO. Just give me a second. Yes. Then talking about what are the positives. What are the positives with respect to NGO? They are less rule bound. They can freely experiment. They are small and flexible. There is lesser hierarchy. The decision making is quick. Helps in building social capital. Easily accessible. There are experts and they have specialization in things. The flexibility is high. So these are the positive. Now what are the negatives? With these were the positive, there are some negatives as well. So let us discuss what are the negatives. So as per a report of IB, it says that because of NGO there is a narrow perspective, and this narrow perspective costs around 2% of GDP loss for our nation. Then there is poor internal governance, and few NGO violates the FCRA regulations also. Then 80% of these NGO are single manned. Then these NGOs are involved in tax evasions, money laundering. Most of them are involved in such activities. And then there is no accountability for the actions of NGOs. Now what are the issues with respect to NGOs. Availability of fund is not adequate. Then there is lack of human resources. Then there is overlapping function with district administration. Then there is over regulation by government, like we have FCRA Amendment 2020, which has vague terms with respect to what is public interest and various other things. Then uh, the freedom is also restricted, and basically all the NGOs are different in their working. What India follows a one size fit all approach for all the NGOs, which won't work because all NGOs are different in nature. Then what we can do? So we can digitalize them, है ना? We can decrease the need for physical interface between NGO and public official. We can modernize the registration process. We can ensure seamless operation of provision of FCRA and the IT Act. Then there can be a three-tier monitoring system for receiving the grants. So basically, these are the measures which we can take to improve the conditions of NGO. Apart from this, what else can be there? Then there can be a national accreditation council to grade the NGOs. The NGOs can be bought under Right to Information Act. Then there should be updated policy on voluntary organizations. Then there should be a law on ensuring internal governance of these NGOs. Then there should be minimal regulations and easy compliance with regulations. So these are the measures which we can take, and we can also, वी कैन नहीं बल्कि ये तो होता ही है दैट सोशल ऑडिट नहीं, क्या बोलते हैं उसको, एक ऑडिटिंग रिपोर्ट जो है दे नीड टू सबमिट एवरी ईयर. अच्छा, इससे याद आया, सोशल ऑडिट इज ऑल्सो अ टॉपिक, सो लेट अस डिस्कस सोशल ऑडिट नाउ. Social audit. Now, what is social audit? It is an accountability tool to measure or evaluate the identity or to identify the gaps in the service delivery, and it is basically done directly by the intended beneficiaries. For example, we have community cards, we have citizen charter. Now, what is the benefit of such things? So it decreases corruption, it ensures efficiency, it ensures accountability, it ensures equity, it curbs malpractices, it improves the quality services, it empowers the citizen. It is a basically a tool of participatory administration on participatory democracy, and then it focuses on outcomes. It has resource sustainability. Then uh, it is also focusing on the accountability and the transparency mechanism through which the accountability is ensured. So these are basically the benefits of social audits. Now, what are the challenges of the social audits? So officials do not adhere to the procedure. Then CAG has limited powers, and the powers which it has, it is mostly post mortem in nature. Then there is lack of awareness, there is lack of penalties, there is lack of political will, there is lack of infrastructure. So all these are the issues with respect to सोशल ऑडिट. अच्छा, एक वर्ड बहुत सबने सुना होगा ना, उसको बोलते हैं बेसिक स्ट्रक्चर. बेसिक स्ट्रक्चर कॉन्स्टिट्यूशन में. अब ये होता क्या है? अगर कोई बोल दे कि एक बताओ बेसिक स्ट्रक्चर, तो मुश्किल ही आप डिफाइन कर पाओ. सो बेसिकली बेसिक स्ट्रक्चर आर द कोर प्रिंसिपल्स or the core values which are considered as an essential pillar of the constitution, and hence they cannot be amended. It is the basic constitutional morality. अब इसका एक इवोल्यूशन मैं बता देता हूँ ब्रीफ में. तो फर्स्ट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट आया. इट ब्रॉट इन आर्टिकल 31A which stated that law violating article 14 and 19 cannot be challenged in court. Then article 31B आया. It said that law placed in the ninth schedule are out of judicial review, and obviously ninth schedule आया. So इसके बाद एक केस हुआ, शंकरी प्रसाद केस वर्सेस यूनियन ऑफ इंडिया। इसमें फर्स्ट अमेंडमेंट एक्ट को चैलेंज किया गया। देन द सुप्रीम कोर्ट सेड दैट आर्टिकल 13 इज ओनली रिस्ट्रिक्टेड टू ऑर्डिनरी लॉ एंड नॉट कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, and it also said that the parliament has the power to change, has the power to modify or abridge any part of the constitution, and even it includes fundamental right. Now what happened after a few years? There came the 17th constitutional amendment act. It added more subjects to the ninth schedule. More subjects were added in the ninth schedule. Then the Golaknath case came. The Golaknath case, Golaknath versus State of Punjab. In this, the Supreme Court says that the Article 13, basically the decision was contrary to the Shankari Prasad case, and it basically kind of overturned that earlier decision, and it says that Article 13 also applies to constitutional amendment acts, and Parliament cannot abridge the fundamental right. The Parliament does not have absolute power. It does not have absolute power. Then this tussle between the judiciary and the Parliament continued. तो इसके अगेंस्ट में then 24th Constitutional Amendment Act लाया गया. What did they said? It said that in Article 13, subclause 4, it said that nothing in this article should apply to constitutional amendment under Article 368. And Article 368 में लिख दिया कि nothing in Article 13 shall apply to an amendment. उसके बाद उन्होंने किया क्या कि 25th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट में आर्टिकल 31C में लिखा कि टू इनैक्ट DPSP any amendment done will not be considered violation of Article 14, 19 and 31. And then Article 31B आया, 31C आया. तो 31B में ये लिख दिया कि no law which has been made to implement Article 31C can be challenged. तो एक तरीके से सब कुछ जुडिशियल रिव्यू के बाहर में गए. तो what did judiciary do in the famous Keshav Nand Bharti case 1973? It gave the doctrine of basic structure. It upheld the power of Parliament under Article 31C, but it said that nothing is outside the ambit or the purview of judicial review. Everything will be inside the purview of judicial review. This is what it said. And anything contrary to this would be struck down by the Parliament. Then what happened next is there was a Raj Narayan case. So this is basically the case where the post of one of the erstwhile prime minister were in danger, and due to this the PM introduced the 39th Constitutional Amendment Act, where it said that any electoral dispute is out of the judicial review. Any of the electoral dispute with respect to 3-4 posts like PM, Vice President, Speaker is out of judicial review. Then this case, due to this amendment, was again struck in the ongoing Raj Narayan case versus state of UP. So this 39th Constitutional Amendment Act was struck down. Then after this 42nd Constitutional Amendment Act came, which is also known as the Mini Constitution of India. इसको तो लक्ष्मीकांत से या फिर DD बसु से एक बार रेफ़र करना, बहुत डिटेल में है, सब कुछ एक बार देख लेना क्या क्या प्रोविजंस थे. फिर मिनरेवा मिल्स केस आता है. इसमें क्या करता है, सुप्रीम कोर्ट स्ट्रक डाउन आर्टिकल 368 सब क्लॉज 4 विच वॉज इंट्रोड्यूस्ड बाय दिस 42nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट ओनली. इसमें सुप्रीम कोर्ट सेड दैट पार्लियामेंट हैज़ limited powers दे डोंट हैव एब्सोल्यूट पावर। फिर एक वामन राव केस था, इसमें इट सेड दैट ऑल लॉज इन द नाइन्थ schedule after 24 April 1973, that is the date when the Keshavanand Bharati case may we got the basic structure doctrine. So it says that all laws in the ninth schedule after 24 April 1973 would be under purview of judicial review. फिर आया द मोस्ट इम्पॉर्टेंट वन, आई आर कोहिलियो केस ऑफ 2007। इसमें सुप्रीम कोर्ट ने कहा दैट द कोर्ट हैज़ पावर टू एग्जामिन द नेचर एंड एक्सटेंट ऑफ वायलेशन ऑफ फंडामेंटल राइट बाय एनी लॉ अंडर नाइन्थ शेड्यूल। तो नाइन्थ शेड्यूल के पास जो ब्लैंकेट था फ्रॉम द जुडिशियल रिव्यू, इसको पूरा ख़त्म कर दिया सुप्रीम कोर्ट ने। अब बेसिक स्ट्रक्चर का इवोल्यूशन तो देखा, बट व्हाट वाज द इम्पोर्टेंस? सो टू चेक द आर्बिट्री डिसीजंस, टू अवॉइड टू अवॉइड बेसिकली द authoritarian behavior, to uphold the constitutional morality, for protection of fundamental right, to create checks and balance, and to reduce legal clashes, and to protect the basic principle, to protect uh, the concept of constitutionalism, है ना? These are basically the importance of this basic structure. And now what were the issues? Issues were that there was excessive power to judiciary, then there is no accountability, then there is vagueness, the vagueness in terms of the judicial ambiguity and subjectivity, then it is against the concept of separation of power. Then there is also issue of different type of interpretation in various different cases. नाउ इम्पोर्टेंस में हमने एक चीज़ देखी थी, कॉन्स्टिट्यूशनलिज्म। चलो इसको भी डिस्कस कर लेते हैं। सो व्हाट इज़ इट? बेसिकली इट इज़ अ लीगल प्रिंसिपल विच मैंडेट्स कंट्रोल ओवर द एक्सरसाइज ऑफ गवर्नमेंट्स पावर टू इंश्योर कि डेमोक्रेटिक प्रिंसिपल ऑन विच द गवर्नमेंट इज फॉर्म्ड इज नॉट डिस्ट्रॉयड। सो बेसिकली इन easy words it means that government or the parliament should be bounded by checks and balances, the controls, there should be controls on the government and the government must follow the rule of law. तो क्या प्रोविजंस है इंडिया में टू ऑफ ये कॉन्स्टिट्यूशनलिज्म के, टू बेसिकली टू लिमिट द पावर ऑफ गवर्नमेंट? So we have separation of power, we have rule of law, we have basic structure, we have federal structure, we have independent judiciary, we have fundamental right, we have regular elections. So all these are provisions which are limiting the power of the government and promoting the values of constitutionalism. Now another important topic is e-governance. E-governance क्या है? It is basically the use of ICT in the field of governance, that is in the process of the decision making and also in the implementation. The government is using ICT. For example, we have JAM Trinity, we have electronic national agriculture market, है ना? तो what are the importance of this e-governance? So first is better delivery of services like pension delivery via JAM Trinity. Then there is ease of doing business, वन स्टॉप सोल्यूशन है, जैसे परिवेश पोर्टल है फॉर एनवायरमेंट क्लियरेंस, हर टाइप के एनवायरमेंट क्लियरेंस एक ही पोर्टल पे मिल जाते हैं. देन द अकाउंटेबिलिटी इज इंक्रीज्ड, ऑनलाइन आरटीआई की फाइलिंग हो जाती है. देन बेटर ग्रीवेंस रिड्रेसल मैकेनिज्म इज देयर. नाउ वी हैव प्रोविजंस लाइक ऑनलाइन एफआईआर. देन देयर इज बेटर मॉनिटरिंग ऑफ schemes. Then there is ease of service like we have e-passports. Then there is participatory democracy. There is less paperwork. For example, we have e-offices. But then there are some issues also. What are the issues? That the lack of content in local language. There are multiple portal apps. There is a digital divide. There is a digital divide, and there is also a digital literacy is also low. Then there is lack of training of administration. There is data privacy. Abhi kuch time pehle we had this, the data of Cowin app was leaked. Then there is threat of cyber crime, cyber security threats, cyber attacks are there. then the infrastructure issue का दिक्कत है, then there is a inertia, there is a resistance for change among the citizens also, and then there is a lack of business process re-engineering. अब this business process re-engineering क्या होता है कि जैसे मानो कि this is suppose this is a building of one office and this is a citizen. Now he can access information and he can access the data which is here in this office, and it can be accessed online by this person. So the link between this first office and this person is online. So one stage of the process is basically online, बट द डेटा जैसे मान लो इस ऑफिस में कोई डेटा जो इस बंदे को चाहिए था वो तो इसने प्रोवाइड कर दिया, पर इस ऑफिस के पास वो डेटा कहाँ से आया? सपोज देयर इज अनदर स्मॉल डिपार्टमेंट, there are multiple departments. So suppose this is a ministry office. मिनिस्ट्री ने अपने पोर्टल पे सब कुछ डाल रखा है एंड दिस पर्सन कैन एक्सेस दैट थिंग फ्रॉम द पोर्टल ऑनलाइन पेज, पर दिस मिनिस्ट्री हैज़ वेरियस डिपार्टमेंट. अब जो डेटा मिनिस्ट्री के पास आ रहा है फ्रॉम दिस डिपार्टमेंट, फ्रॉम दिस डिपार्टमेंट, फ्रॉम दिस डिपार्टमेंट, फ्रॉम हेयर, फ्रॉम हेयर, फ्रॉम हेयर, ये सारा डेटा ऑनलाइन नहीं आ रहा है, ये अभी भी ऑफलाइन पेपर वाले मोड से सारा लेटर्स वाया पोस्ट चलती हैं चीज़ें, और सारी वो डाक वाला सिस्टम अभी भी चालू है. तो ये वाला प्रोसेस तो ऑनलाइन हो गया है, बट दिस प्रोसेस अभी भी इज़ इन ऑफलाइन मोड ओनली. तो दिस नीड टू बी री इंजीनियर्ड. सो दिस इज बेसिकली कॉल्ड एज देर इज़ अ लैक ऑफ बिजनेस प्रोसेस इंजीनियरिंग. Then what are the initiatives for promoting e-governance? We have Digital India, we have BharatNet, we have Umang app. Umang app is basically to merge and bring all services on one platform only. What else we can do? We can way forward में क्या लिखेंगे? We can have single window process. We can have business process engineering. We can have involvement of the private public players. Then we can promote the capacity building of the administration. For example, in Hyderabad, there is a Hyderabad declaration on e-governance, है ना, which also said these four same points. Then we can work on data privacy, data security. We can have some awareness campaigns, and we can increase the security of the critical infrastructure like the banking हो गया, the power sector, the Aadhaar. We need to increase the security of this. So that is all for this topic of. तो इसके बाद नेक्स्ट टॉपिक ऑफ डिस्कशन है रेगुलेटरी बॉडीज. Regulatory bodies. What are regulatory bodies? So basically these are agencies working toward implementation of rules and regulation in a specific sector to basically ensure smooth functioning of the sector. So these also set standards, and they also have the power to enforce those standards. Now the question is, what was the need of such regulatory bodies? First is smoothing the function of the sector, ensuring setup of standards in the sector. Basically, you can write here the example of UGC, which gives the NAC accreditation to the universities. Then to avoid monopoly, to reduce information asymmetry, to promote healthy competition, act as a grievance redressal mechanism, protect the citizens, ensure the transparency and accountability, and coordinate among stakeholders. Now, what are the issues with respect to such regulatory bodies? First is the issue of over-regulation. There is a regulatory cholesterol phenomena in India. Then the appointment is by government. Then the recommendations are not binding. Then there are issues with respect to enforceability. Then there is a poor parliament oversight. Then there is politicization of these bodies with inexperienced recruitments. Now, what can be the way forward? So second ARC has suggested some measures. That is, first review before appointment should be there, regulatory impact assessment should be there, and there should be clear cut objective defined while setting up of the bodies. there should be merger of some of the regulatory bodies with overlapping function, and then there should be uh, sorry, there should be transparency in the appointment. So we must focus on moving from over regulation to self regulation. दिस शुड बी आर फोकस. अच्छा, इसी टाइप में इंडिया में एक बॉडी है, कंपटीशन कमीशन ऑफ इंडिया. थोड़ा सा स्पेसिफिकली उसके बारे में पढ़ लेते हैं बिकॉज इट हैज़ बीन इन द न्यूज़. इट इज़ अ स्टैट्यूटरी बॉडी. 2000 में एक्ट आया था, कंपटीशन एक्ट. देन इट हैज़ चेयरमैन प्लस 6 member appointed by the central government. It acts as a watchdog of the Indian markets and it prevents cartelization. What are the issues with respect to this body? First, it is a toothless body, so it can only collect 1% of the fines it has imposed. Then it also has overlapping function. It has acted in a biased way. For example, in the Jio case, तो एयरटेल ने कंप्लेंट किया था अगेंस्ट जियो, बट विद रिस्पेक्ट टू सम रेट इश्यूज वहाँ पे कंपटीशन कमीशन ऑफ इंडिया की थोड़ी सी बायसनेस दिखी थी. देन इट लैक एक्सपर्टीज एंड इंडिपेंडेंस. देन देयर इज स्लो डिसीजन मेकिंग. फिर अभी कंपटीशन अमेंडमेंट एक्ट आया था 2023 में, जिसकी वजह से ये सारा सिग्निफिकेंट हो गया. तो अर्लियर ना 150 डेज का टाइम दिया जाता था CCI को टू टेक डिसीजंस. अब इसको अर्लियर इट वाज 210, अब इसको 210 से रिड्यूस करके 150 कर दिया है. फिर प्राइमा फेसी ओपिनियन देने के टाइम को 30 डेज कर दिया है. देन पेनल्टीज़ को जो है इंक्रीज़ कर दिया है. देन इट हैज़ ऑल्सो हैज़ प्रोविजन ऑफ 25% penalty submission to appeal against the decisions of the commission or to appeal in some appellate tribunals. तो ये हुआ है. ऐसे ही वन मोर इम्पॉर्टेंट टॉपिक इज़ विद रिस्पेक्ट टू ड्रग रेगुलेशन इन इंडिया. सो इन 2023 में एक इंसिडेंस हुआ था कि दैट अ कंपनी ऑफ आई ड्रॉप चेन्नई में इट हैड ड्रग रेजिस्टेंट बैक्टीरिया. देन इंडिया में एक चीज़ है कि 20% ऑफ ड्रग्स इन इंडिया आर काउंटरफीट. तो दिस इज़ अ सीरियस थ्रेट. अब हाउ ड्रग्स आर रेगुलेटेड इन इंडिया, तो एक्ट क्या है उसके लिए? एक्ट है ड्रग एंड कॉस्मेटिक एक्ट ऑफ 1960. देन दूसरा रेगुलेशन मैकेनिज्म होता है कि यू हैव सम बॉडीज. सो वी हैव CDSO, दैट इज सेंट्रल ड्रग स्टैंडर्ड कंट्रोल ऑर्गेनाइजेशन. व्हाट इट डज, इट अप्रूव्स न्यू ड्रग्स. It approves the clinical trial of the new drugs. It gives licensing with respect to blood serum vacancies. It gives license with respect to medical devices. It gives license to blood banks. And the licensing is also required for the imports also. So this is the function of CDSO. Now who works on the behalf of CDSO? DCGI, that is the Director Drug Controller General of India. He works on the behalf of this thing, CDSO. We also have the states drug regulatory authority also at state level. What does these do? These do the inspection work. They look into the objectionable ads with respect to drugs, and they also draw samples for testing and monitoring. They have the power of licensing of drug, and they also have the power to license the manufacturing establishments. Another body, we also have National Pharmaceutical Pricing Authority, which looks into the matters of the pricing. Basically, this is the authority which is deciding the medicine prices in India. Then now what are the issues with respect to this? The issues is lack of infrastructure. Our drug act, it is not 1960, it is of 1940. It is an archaic act. It is obsolete because now we have emergence of new technologies, we have new threats, new drug related issues. Then a parliamentary standing committee said that the DR, that is the Drug Regulatory Authority, it lacks transparency. Then there is slow approval process. Then there is there is a web of regulatory authority created, and also there is no standardization of manufacturing process. So apart from this, there is lack of public database and history of brands. So there was a book named The Truth Pill, the myth of drug regulation in India. So this book mentions that there is lack of public database, there is lack of history of the brands. So what do we have? We have the new drug and medical devices and cosmetic bill 2020. Now what provision this bill has? So basically this bills regulates e-pharmacy, it regulates medical devices, it regulates Ayush drugs, it has new definitions. For example, we have definitions of bioavailability trial. Then we have medical device technical board, which will be established under this act. Then we have penalties for the violation of the act. Then there is also focus on providing compensation to the victims in this act only. So this was about the new bill. Actually, this is not an act, this is a bill. Okay, now moving on towards our next topic, that is uh, election system. Now election system, we have first past the post system. Apart from this, there is also a system known as proportional representation, which we use in the election of president. So first of all, for the Lok Sabha one, why is this FPPS? Uh, why is this FPPS adopted? So the reasons for why it has been adopted is, first, it is very familiar to us because the British or the colonial legacy left it. Then the process is simple, not very complex like the proportional representation. Then it is the administrative feasibility is there. There is a direct accountability mechanism. Then there is a strong government, and it also reduces fragmentation. But now, what are the issues? So issues are NDA or India Alliance. So if you see voting percentage difference, the vote percentage difference between both the parties is just a margin of 2 to 3%. But in the seats, it's the margin is around 20%. Then there is exclusion of minor parties. Then there is wastage of votes. For example, BSP got around 4% votes in the Lok Sabha election, but they got 0 seats. So these 4% voters, this 4% सुन के कम मत समझना, लाखों में होंगे ये. तो लाखों लोगों के वोट वेस्ट हो गए क्योंकि एक भी सीट नहीं मिला. देन मेजोरिटी रूल्स विद द माइनॉरिटी सपोर्ट, ये एक इशू है. देन वोटर एपैथी इज ऑल्सो इशू. अब वाई वी आर प्रपोजिंग PR एज अ सोल्यूशन, उसके क्या बेनिफिट है? सो फर्स्ट इज the seat allocation in this is based on the vote share. So there is a fair representation, there is more inclusiveness, there is less wastage of vote, every vote matters, there is flexibility of candidate, this enhanced political engagement, and coalition government is promoted, and therefore consensus building is there, and the decision making is relatively easy. Plus it also prevents extremism, extremist ideologies are prevent. But this also have some issues. Now what are the issues related to this? This lacks strong government, there is delay in decision making, there is dilution of accountability, there is risk of fragmentation, there is risk of unstable government, there is weak link between the constituency. अब जैसे फॉर एग्जांपल राज्यसभा में देर इज़ नो डोमिसाइल क्राइटेरिया. सो वन ऑफ आर मिनिस्टर मिस्टर S. Jaishankar is being elected as a member of Rajya Sabha from a seat from UP. He has no background, he has nothing to do with that particular seat from UP, which from where he is nominated to the Rajya Sabha. How can he administer the justice with the people of the UP when he is not from UP? He does not have any background of UP. तो NCRWC के कुछ सजेशंस थे. दिस इज नेशनल कमीशन ऑन रिव्यू ऑफ वर्किंग ऑफ कॉन्स्टिट्यूशन. So this suggested that there can be a hybrid system where two-third of the seats could be allocated to the first past post system and one-third to proportional representation. And second ARC also said that there is a need to slowly shift towards the proportional representation system. And you can write the case study of Germany and New Zealand जहाँ पे hybrid system is used. Some seats. सिमिलरली इसी से रिलेटेड एक और कॉन्सेप्ट है डिलिमिटेशन का. तो व्हाट इज डिलिमिटेशन, व्हाट इज द नीड फॉर डिलिमिटेशन एंड व्हाट आर द इश्यूज विद रिस्पेक्ट टू डिलिमिटेशन. So basically, delimitation is the process of redrawing the boundaries of electoral constituency and determining the number of seats. So in our constitution, in Article 82 and Article 170, there is a mention of the delimitation process, and it has to be done through a delimitation commission. Now, what is the need for delimitation? So in 1971 and 2021, the population was around 55 CR in 1971 and there were 543 seats. So that turns out to be an average of 10.1 lakh population uh, per seat, है ना. बट 2021 सेंसस तो हुआ नहीं, बट एक अंदाज़ा ये है कि नाउ वी आर 142 करोड़ with still 543 seats. What that amounts to be? That amounts to be one seat per 25.8 lakh population. So this is very difficult to administer. एंड ये इसमें भी डिस्क्रिपेंसीज हैं. कुछ स्टेट्स में ये बहुत ज़्यादा है नंबर, ये तो एक एवरेज है, बट इफ़ यू सी स्टेट वाइज नो द डिस्पैरिटीज आर वेरी लार्ज. सो इन यूपी अलोन, इन यूपी में यू हैव somewhere around 30 lakh population per seat. So it is limiting the fair representation of the people also. So with delimitations, what we'll get fair representation, we'll get improved governance, we'll get administrative ease, and there will be obviously inclusivity. But there are some issues with respect to the delimitation. Now, what are the issues? First, that the southern states will be penalized. How they'll be penalized? So when there was uh, so sorry so when there was a time to take measures with respect to controlling population, southern states performed very well and they were able to slow down their population growth. But the northern state, the population kept on increasing rapidly and at a higher rate. Now, how is the delimitation done? It is done on the basis of the population in a particular area. So, if the southern state, the population is less, they will be getting less representation, less seats in the Lok Sabha. Whereas in the northern state, the population is high and their seat allocations will also be high. So, the southern states will be penalized for their good work. Then, northern state, again they would give up the population control measures, because उनको तो दिख रहा है कि when they are having more population they are getting more seats, more representation. So why they will control the population. So and इसको सपोर्ट करने के लिए एक आप फैक्ट लग सकते हो कि अगर एग्जांपल देखें, if delimitation will happen, no, UP will get 60 more seats whereas Telangana will get only 20 seats. Now you see this penalizing of the southern state. So this is one issue. Then census data is not available, obviously that is an issue. Then there is concern with respect to reserved seat. जो reserved seats women के लिए reserve करी गई हैं, then there is a concern कि इन seats को equally all over India distribute ना करके these seats will be distributed as per the political will and it will ultimately favor the political motives of the ruling party, है ना. So this is also an issue. Now what is the solution? So we can increase the number of seats of MLA rather than increasing the number of seats of MP. Then we can strengthen the urban local body, the Panchayati Raj institution. That is also going to be a great initiative. Then USA में एक example we can write that USA has equal proportional रिप्रेजेंटेशन सिस्टम, तो वो हम अडॉप्ट कर सकते हैं. सो दीज आर बेसिकली द सॉल्यूशंस फॉर दिस इशू. नाउ आवर नेक्स्ट टॉपिक विल बी सो इंडियन डायस्पोरा. अब इंडियन डायस्पोरा है क्या? सो बेसिकली इट इज़ द ग्रुप ऑफ पीपल हैविंग ओरिजिन इन इंडिया एंड रिसाइडिंग आउटसाइड इंडिया इधर टेम्परली और परमानेंटली इज बेसिकली द इंडियन डायस्पोरा. अब वर्ल्ड बैंक का डेटा कहता है कि वी हैव अराउंड 18 मिलियन डायस्पोरा अराउंड द वर्ल्ड, बट आवर मिनिस्ट्री ऑफ एक्सटर्नल अफेयर्स says that we have around 32 million. ये PIB में आया हुआ है क्योंकि ये डेटा PIB का है. 32 million person of Indian origins and NRIs. So we have a strong Indian diaspora. World Bank की एक report थी which says that India is the largest receiver of remittances also. Around and 2022 only around $100 billion is what we have received as remittance. So this is very high. अब डायस्पोरा पॉलिसी विद रिस्पेक्ट टू इंडिया के कई फेज़ रहे हैं. जैसे डायस्पोरा पॉलिसी देखें तो फर्स्ट वाज आर नेहरूवियन फेज. इसमें व्हाट वी डिड, इसमें देयर वाज कॉन्सेप्ट ऑफ नॉन इंटरफेरेंस एंड लिमिटेड इंटरेक्शन विद द डायस्पोरा. देन फिर सेकेंड फेज आया विच वॉज द फेज ऑफ राजीव गांधी मॉडल. हेयर वी इन्वाइटेड द इंडियंस रिगार्डलेस ऑफ their nationality to come and work in India and work for India. And one of the example is Sam Pitroda, है ना. Then third we see is the current Modi era. Here Indian diaspora has become a keystone of our international policy. We have a proactive approach to reach out to the Indian diaspora. Then what is the role of the diaspora? Why we are trying to reach out the diaspora and why we are saying that it's a keystone to our international policy? Because it has first is the economic benefit, we get remittances. Then benefits with respect to technology and knowledge also. Then it is also a political asset where we can it is also the known as track 2 or track 1.5 diplomacy. Or other than that, it is also used as a tool for other benefit is with respect to the friendshoring initiative that we have. Then this diaspora is also in the leadership position of various global institutions like we have IMF, in Google, etc. Then there is also a creation of social capital for more emigrant. Like आप लोग भी कहीं अगर इंडिया में ही अगर किसी स्टेट से भी आपको बाहर जाना होगा तो आप पहले देखोगे ना कि वहाँ कोई जान पहचान का रह रहा है क्या. So in that ways. Then there is limitation in diaspora diplomacy. What are the limitations? So basically the limitation is risk of interference in other states' policy. Then there is a risk of identity crisis for the diaspora itself. कि it should वो खुद को कहाँ से जो है वो करता है, what do we say, हाँ, from where the diaspora is associating himself or herself as an Indian or as a resident of the country where he or she is currently living. Then there is diverse political ideology issue also with respect to various groups like the Khalistani and their movement in the Canada. Then what is the issue with Indian diaspora? With example, I'll tell you. In Middle East, there are issues like contract violation, wage-related issues there. Then there is poor working condition. In Europe, we have issues of violence. We have issues of racial discrimination. We have anti-nationalist ideology like the Khalistani movement in the Europe and the USA. Then we also have issues of human trafficking. We have issue of anti-globalization. For example, we have Nitakat law, which remove overseas worker by local labor, है ना. तो local labor will replace the overseas labor. तो जो लोग हमारे यहाँ से गए हैं उनकी नौकरियाँ चली जाएंगी. So this law is a problematic thing for our immigrants. Then there is a phenomena of discovering Indians in crisis. So wherever there is a crisis, वहीं से there are news that वहाँ पे इंडियन लोग हैं, इंडियन डायस्पोरा के लोग हैं, and now we have to look at their welfare. So this is the concept of uh, discovering Indians in the crisis. So there have been some government initiative also with respect to our diaspora. We have Pravasiye Bharati Divas. We have No India program, Jano Apna Desh. We have the OCI and PIO cards being merged. Then we have Pradhan Mantri Kaushal Vikas Yojana and the Parliamentary Committee on International Affairs. So it recommended certain things. So what were the recommendation? Recommended that the embassy should feel like home away from home, है ना? And there need to be strong rehabilitation measures also. So that's it for the diaspora wala topic. Now the next topic is a role of civil services. So in Article 310, there is a pleasure of doctrine that these civil servants, especially the all Indian ones, they are working on the pleasure of the president. They are appointed by the president. Then there is a 311 article which says any civil servant cannot be removed by a subordinate authority by a authority which is at a subordinate level than the what do you say appointing authority. Then we also have Article 312 where there is the power for Raj Sabha to create all India services. Now, what is the competency framework for civil services? So, the competency framework for civil services is ethos. It is basically 4E. 4E. 4E stand for ethos, ethics, efficiency, and equity. So, what do you mean by ethos? Ethos is basically doing the public good, doing your work in a citizen centric matter. Then ethics is being honest, being transparent, being accountable. Then efficiency is using the resources sustainably. And what is equity? Equity is justice, empathy. Now, what is the role of a civil servant in a democracy? It is to implement the policies for the service delivery to the public. Then it also acts as a bridge between the government and the governance. Then it provides continuity in administration. Then it also acts as a crisis manager, and it also acts as a grievance redressal mechanism. Now, but we also have some issues with respect to our civil services. We have a red tapeism, we have the status quoist mindset among the bureaucracy, then we have sanskritization of corruption, then there is a nexus between politician and bureaucracy, and sometimes this also is extended to criminals also, a triangular nexus between politicians, bureaucrats, and criminals. Then there is a elitist mindset among the bureaucrats. Then they are not directly accountable to the people, so there are issues with respect to accountability. Then Article 311 provides for the uh, gives them excessive protection because subordinate authority then the appointing authority cannot remove him, so he's not accountable to anyone other than the appointing authority, so there is excessive protection provided to him. Then there is poor work culture, then there is bureaucratic indecision and risk diversion, then there is also issue with respect to frequent transfer. So one of the thing is that we can have a civil services board which will look at the transfer of civil services, will be headed by a cabinet secretary level officer, and this will reduce political interference. And but the thing is with this board, the thing is this board's recommendations are not binding, so this is one of the issue with this board also. Then there is lack of compliance, there is lack of accountability in this board. So though this board is a good initiative, but it has its own problems also. So this topic is also done. Now let's move on towards a new topic, that is fundamental duties. fundamental duties. So basically, there was a case. The name is Durga Dutt versus Union of India, where the Supreme Court said that the court cannot direct the parliament to enforce, to bring in a law to legally enforce the fundamental duty. And the Supreme Court also said that there are already various law existing to enforce fundamental duties. For example, we have Article 51A, subclause F. This talks about protection of cultural heritage. So, for this, we have the Ancient Monuments, Archaeological Sites, and Remnants Act of 1958. So, we have already a law. So, this is one of the example. We have multiple laws. So, the Supreme Court says that we have law, and we cannot direct the parliament to pass some law to legally enforce this fundamental right. So this was a judgment, I think 2022. Now let us know something about fundamental duties, and let us discuss fundamental duties topic in a comprehensive way. It was inspired from USSR, and major democracies in the world, you will see they won't have this fundamental duty, like USA, Australia, France, Germany, Canada. They don't have fundamental duties. Only another democracy apart from India where we can see fundamental duty is Japan. Then now how this fundamental duty came in? So in the 86th Constitutional Amendment Act 2002, there was a addition to the DPSP, wherein Article 45, 0 to 6 years age education, but the children of 0 to 6 years age will get education. This was stated in the DPSP, and in the same and apart from this, Article 21A, it had provision of 6 to 14 years complementary education for children under 6 to 14 year. अच्छा, मैंने क्या ये बोल दिया क्या कि 86 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट से आए थे फंडामेंटल ड्यूटीज़? नहीं, 86 कॉन्स्टिट्यूशनल अमेंडमेंट से तो एक बार फंडामेंटल ड्यूटीज़ को अमेंड किया था। आर्टिकल 51 में 51A में सब क्लॉज के डाला था। ये एक एक्स्ट्रा ड्यूटी 81 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट से आई थी, 86 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट से आई थी। बाकी तो फंडामेंटल ड्यूटीज़ उस अमेंडमेंट से नहीं आई हैं। सो बेसिकली व्हाट डिड दिस डू? 51 सब क्लॉज ए का, 51A का सब क्लॉज के, ये 86 कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट से ये वाला जो है ना 6 से 14 ईयर्स जो फंडामेंटल राइट में ऐड किया है, तो ये पेरेंट्स के ऊपर जो है, पेरेंट साइड पे ये लिखा गया था, इट्स अ ड्यूटी ऑन द पेरेंट साइड टू प्रोवाइड अपॉर्चुनिटी फॉर education, for giving opportunity of education to his child in the age between 6 to 14, है ना? तो this was the thing. Now let us see what were the features. So features में first is that the fundamental duties are non-judiciable. The fundamental duties are non-justiciable. एंड इसीलिए वो दुर्गा दत्त वाला केस मैंने आपको बताया था. देन अपार्ट फ्रॉम दिस दे प्रमोट नेशनल यूनिटी, दे हैव प्रोविजंस फॉर एनवायरमेंटल प्रोटेक्शन, दे एनकरेज साइंटिफिक टेम्पर, दे प्रोवाइड सपोर्ट्स टू एजुकेशन, एंड द फंडामेंटल ड्यूटीज आर एप्लीकेबल ओनली टू द सिटीजन्स, है ना, एंड दे आर बेसिकली रूटेड इन द इंडियन ट्रेडिशन, एंड ऑल्सो देर इज़ अ मोरल एंड सिविक ऑब्लिगेशन ऑल्सो. और इसी को ना नोट्स में एक ये भी ऐड कर लेना, ये जो मैंने यहाँ पे गलती से 81 बता दिया था, 86 वो था 51 कॉन्स्टिट्यूशन फॉर 51 आर्टिकल ए का सब क्लॉज के लिए था वो. इन जनरल दिस आर्टिकल 51A जो फंडामेंटल ड्यूटीज़ का है, ये ऐड हुआ था बाय योर 42nd कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट, है ना. तो ये याद रखना, कंफ्यूज मत होना. देन व्हाट आर द importance with respect to fundamental duty, this Fundamental duty, the importance is first is it balance fundamental right and fundamental duty, because the rights are individual, the duty is collective. और एक एम्स स्टूडेंट्स यूनियन वर्सेस एम्स एक केस था सुप्रीम कोर्ट में, जहाँ सुप्रीम कोर्ट सेड दैट द फंडामेंटल राइट्स and fundamental duties are inseparable. Then it acts as a reminder of the responsibilities of the citizen. Then it acts as a warning against anti-national activity. It promotes nationalism and patriotism. It fosters national integration and strengthens the democracy. It brings in discipline and commitment. It boosts the civic consciousness and it strengthens the judicial review mechanism. इसमें एग्जाम्पल लिख सकते हो जो विशाखा गाइडलाइंस वाला केस था, तो विशाखा वर्सेस द स्टेट ऑफ राजस्थान, उसी में सुप्रीम कोर्ट ने विशाखा गाइडलाइंस दी थी. तो दैट वाज आल्सो अ केस विद रिस्पेक्ट टू फंडामेंटल ड्यूटीज ओनली. देन इंडियन फिलॉसफी भी है, द फिलॉसफी ऑफ कर्मा, जो कि फंडामेंटल ड्यूटीज़ में रिफ्लेक्ट होती है. एंड महात्मा गांधी ने एक बार बोला था कि दैट द रियल राइट्स आर रिजल्ट ऑफ परफॉर्मेंस ऑफ ड्यूटी. अब फंडामेंटल ड्यूटी और फंडामेंटल राइट का क्या कोरिलेशन है? सो बेसिकली 3 तरीके का कोरिलेशन होता है कि राइट ऑफ वन इज़ द ड्यूटी ऑफ वन, right of one is duty of others, and third is if one violates right of other, it does not make others free to violate the right of one. So ये 3 चीज़ें हैं. अब प्रॉब्लम क्या है with respect to fundamental duty? What is the problem? So the problem is there is an incomplete list. इसमें ड्यूटी टू पे टैक्स, ड्यूटी टू वोट, ये नहीं मैंशनड है. देन वेग और एम्बिग्यूअस टर्म है, दैट नोडल आइडियाज़, साइंटिफिक टेम्पर, इनका क्या मतलब है किसी को नहीं पता. देन दीज आर ओनली मॉरल परसेप्ट. जब लीगली एनफोर्सेबल ही नहीं है तो सिर्फ कहने की बात रह गई ना. और इसी से अपना आगे अगला प्रॉब्लम इज दैट इट इज़ जस्ट रिकमेंडेटरी इन नेचर, नॉट लीगली एनफोर्सेबल. देन दे आर रिडेंडेंट एंड सुपरफ्लुअस. तो वॉट एवर इज मैंशनड इन द फंडामेंटल ड्यूटीज़, मोस्टली वो सब चीज़ें तो वैसे भी हो ही रही थी ना, उसके लिए अलग से क्या लिखने की ज़रूरत थी. So they are basically redundant. Now what is a way forward with respect to this topic? Way forward. So the way forward is Justice GS Verma committee बनी थी एक. So it said that incorporating fundamental duties in education curriculum is one of the measures which we can take. Then we need to have awareness campaign with respect to fundamental duties. Then we need to give legislative backing to this fundamental duties. Then we need to have some penal provisions to create deterrence. And at last and the most important, we need to build interconnections between the fundamental rights and the fundamental duties. So this topic is done. इसका स्टैटिक पार्ट एक बार लक्ष्मीकांत से या डी बसु से और रिवाइज कर लेना. देन CAG इज़ आर नेक्स्ट टॉपिक. आर्टिकल 148 से 151 तक टॉक्स अबाउट CAG. What is the role of CAG? So basically the role of CAG is to audit the expenditure, like it does the finance auditing, है ना, it does the compliance auditing, then it has to do the performance audit, then it ensures accountability, it is a friend philosopher guide to the public account committee, it has advisory roles, it supports anti-corruption measures, it is the guardian of the public purse. अब ये CAG का आप एक ये चार्ट बना सकते हो कभी भी काम आए तो. CAG brings transparency, transparency brings accountability, and accountability plus transparency brings good governance, and good governance brings feedback mechanisms, and feedback mechanisms will again bring in transparency. So you can draw a chart like this to show what a CAG actually does. Now CAG has a security of tenure. It is ineligible for further appointment, and the salaries can't be altered because they are charged on the Consolidated Fund of India. So the administrative expenses charged on the Consolidated Fund of India. And we have various cases where CAG has done very good work like the Air India audit, the Commonwealth Games audit, the Manrega audit, the 2G spectrum audit. All these are examples of good work done by the CAG. But now what are the issues with respect to CAG? So if you see in 2014 to 2018, there were around 40 CAG reports coming out annually. But in 2023, only 18 reports came out. So there is a decline in the number of annual report. Then the staff strength is also decreased. In 2014, it used to be to 25,000 people working. But in 2024, it has came down to 20,000 only. Then the budget allocated to the audit department has came down from 0.19% to 0.13%, which is very low. Then the post is dominated by the IAS, Indian Administrative Service, rather than the Indian Audit, Account and Audit Services. So there is conflict among these two also. Then there is limited power with respect to the public-private partnership project and Panchayati Raj institution projects also. Then it is a single member body, so administrative दिक्कत होती है. Then the reports are very technical and complex in nature, जो लोगों को समझ में भी नहीं आती है जल्दी. Then the appointment process has no collegium. It is directly appointed by the central government. So will a CAG appointed by a central government allow anything to be audited against the central government? Or if a CAG is a IAS officer and he has implemented some schemes, will he allow, matlab, he can, but there is a rare case that he will. Mostly the chances are that he won't allow the auditing of the scheme which he has implemented and he has planned, है ना. और अगर करेगा भी तो the quality of work might be very poor or the report will be very poor, या फिर उसमें फैक्ट सारे होंगे नहीं. देन इट हैज़ अ पोस्टमार्टम वर्क, क्योंकि जो भी कर रहा है ऑडिट वो तो सब कुछ होने के बाद कर रहा है ना. तो नाउ व्हाट्स द नीड, जो जाना था वो तो चले ही गया. व्हाट रिफॉर्म्स वी कैन टेक, वी कैन टेक कैपेसिटी बिल्डिंग हो गया, ट्रेनिंग हो गया, ऑटोनॉमी हो गया, समन पावर हो गया, प्रोएक्टिव रोल हो गया. तो ये रिफॉर्म्स आ सकते हैं. पर ये जो पोस्टमार्टम वाली चीज़ है ना, कि ये पोस्टमार्टम वाला काम है, तो कहीं ना कहीं ये ठीक भी है और गलत भी है. कि पोस्टमार्टम का रोल है तो पैसा तो करप्शन में चला गया या घपला हो गया, तो पैसा तो अब पब्लिक का वेस्ट हो गया है. बट स्टिल ये पता चलने के बाद अकाउंटेबिलिटी तो हम इंश्योर कर सकते हैं ना. एटलीस्ट अगले इलेक्शंस में क्या करना है वो लोग देख सकते हैं. सो उस हिसाब से देखा जाए तो वी नीड दिस. बट इसमें एक रिफॉर्म ये कर सकते हैं कि खर्चा करने से पहले CAG का कुछ रोल होना चाहिए, कि उसको डिफ़ाइन करना चाहिए या उसको कुछ प्लान्स बताना चाहिए कि कैसे वो खर्चे को और एफिशिएंट बनाया जा सकता है. सो वो एक चीज़ रिफॉर्म करी जा सकती है. पर पोस्टमार्टम वर्क का मतलब ये मत समझना कि CAG चाहिए ही नहीं. CAG तो चाहिए भाई, ऐसा नहीं है कि वो बिल्कुल ही नहीं चाहिए. सो या दैट्स इट. अपार्ट फ्रॉम दिस, जो IR का पार्ट है, GS-2 के लगभग इम्पॉर्टेंट टॉपिक्स कवर कर लिए. IR का पार्ट बहुत ही कंटेम्प्रेरी, बहुत ही डायनामिक होता है. तो